Good morning, everybody. Happy Tuesday. Welcome to TCF Live. My name is Dan Sowell. I will guide you on this 3-hour journey through Courtlandia today. We'll start in the 44th District, Royal Oak, Michigan. This is Magistrate Urich.
Yes.
All right. Might you be able to activate your camera?
Yes.
And as you do so, Mr. Dixon, you were present earlier when the court explained the informal hearing process, correct?
Yes, I was.
And so you understood the court's instruction that you must select from one of three options.
Yes, sir.
Thank you, Mr. Dixon. The citation before the court was issued May 10 this year at 11:15 in the evening. You were operating a 2021 Cadillac white in color on Coolidge Highway at or near Edwards in the city of Berkeley. And at that place and time, please stand by. Let's see here. It's on the place. At that place and time, you were issued a citation for no proof of insurance. That appears to be the only ticket that is before the court today. Mr. Dixon, you may admit responsibility. You can admit and explain, or you may deny responsibility, and the court will swear the parties and take your testimony. What do you wish the court to do for you?
So I do got the proof of insurance, but
Okay.
I got two of them. It should have been two.
Stand by. Because the court does, there it is.
Yeah.
Appreciate that. It only appears on the docket once. So, Mr. Dixon, you were also cited on the same date and time for impeding traffic. The court would note that impeding traffic is a 0-point violation that does not record on a master driving record. And the court wishes to be very clear that officers often issue impeding traffic tickets in the place instead of a speeding traffic as some form of leniency or forgiveness to a motorist.
Mm-hmm.
The traffic code violation that Officer Donnelly suggests he saw was speeding by a margin of 12 miles over the 35-mile-an-hour speed limit there, but he chose to write this up for impeding instead. So you are correct. There are two citations before the court. They're both 0 points, no proof of insurance, and impeding traffic. Do you wish to admit on these citations, admit and explain, or deny responsibility?
I'll admit and explain.
Very well. So on the date in question, you were operating a motor vehicle in the city of Berkeley. You were unable at that moment to produce proof of insurance to the officer in a physical form on his request. And in some form or fashion, you impeded traffic, correct?
Yes, sir.
Thank you. The court is so grateful for you, plea. Mr. Dixon, what do you want to tell the court?
At the time, I had just got the vehicle. I couldn't find my insurance. He kind of was just like, you know what, just show it when you get it. I do got the insurance. And just honestly, on the impeding traffic, I was in the area that I really wasn't familiar with. And I kind of just didn't see like the actual speed limit. So I guess, I guess I was speeding, like it kind of got away from me because I didn't actually know the speed limit. But he said I was doing 12 over. I said, hey, I apologize. And, I pulled over right away once he got behind me. And he was pretty fair.
Okay. That's generally what many of the jurists in this court seem to understand with respect to Officer Donnelly, but each and every case must be judged on its merits. So with that said, do you have your proof of insurance?
Yes, sir.
And could you just hold it up to your device so
Yep.
the officer might be able to see it? Sorry?
I was wondering, can I flip the camera? But I guess I'll just show it to you like this.
Yeah, that's fine. Don't worry about flipping the camera. All right, bring that in a little closer and say your name.
So my name is Mario Dixon. The car is registered under my mom name, Gail Dixon, but I'm a registered driver on the insurance.
Okay. The most important piece, there we go. That's a thumbs up. Does that thumbs up take the form of a motion on the insurance?
Yes, Your Honor, motion to dismiss.
All right, that one was expensive. Mr. Dixon, with respect to the impeding, the fine for that is $175. Again, that's 0 points and won't abstract. That is payable through the pay portal on the 44th District Court website, or you may walk the cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday, between 8:30 and 4:30, due within 14 days. Thank you
Okay.
so much for your professionalism. Have a great day.
All right, you too.
Calling case number 26, B like Berkeley E 02595. This is People versus Andrea Alexander Tavares. That's you.
Yes, sir.
Mr. Tavares, you were present earlier when the court explained the informal hearing process, yes?
Yes, sir.
So you understood the instruction that you must select from one of three options to protect your rights, yes?
Yes, sir.
Mr. Tavares, a citation before the court was issued May 22 this year at about 9:30 in the evening. You were operating a 2017 Subaru Outback, blue in color, on 11 Mile Road, near Greenfield, City of Berkeley. At that place and time, it was discovered that your vehicle plate had expired on your birthday in February. You
Yes,
can
sir.
admit responsibility, you can admit, explain, and display an updated registration, or you can deny responsibility, and the court will commence your trial. What do you wish the court to do for you, sir?
I will admit responsibility and submit the registration.
Terrific. So you were driving a motor vehicle in the city of Berkeley with an expired tag that night, but you have since taken care of it.
That is correct, sir.
All right. Could you hold that new registration up?
Yes, sir. Let me see if I can get it in view.
All right. Freeze. Say your name.
Andrea Tavares.
Terrific. Thumbs up generally means a motion to dismiss. And so you don't have a problem with that, do you, Mr. Tavares?
No, sir.
All right. You're a young man. You're going to keep having to do this every February for about the next 60 years if we want to keep driving. Okay.
Absolutely, sir.
All right. Good luck to you.
Thank you.
The court calls case number 26, B like Berkeley E 02406. This is People versus Christina Marie Tomlinson. That's you? All right, you can unmute yourself. It's the red microphone. You should just be able to tap it. Okay, Ms. Tomlinson, we'll take a couple more while you're in.
There we go. I got it.
There
Sorry.
you go. You're fine. Ms. Tomlinson, today is the date and time set for your informal hearing. An informal hearing is non-criminal. No one's going to jail this morning on these documentary traffic tickets. But they are considered serious enough that the officer issued them on the date in question. That date was May 13th, this year at about 7:45. You were operating a 2008 Ford, red in color, on Coolidge Highway.
Yep.
At or near 11 Mile Road, in the city of Berkeley. And at that place in time, you were cited for driving with a plate that expired on your birthday in April. And you were unable to produce proof of insurance for the officer at his request. These are 2 0-point documentary tickets that are non-moving. You may admit responsibility. The court will attach a fine between 0 and the maximum, and that will close the case. You may admit responsibility with an explanation and display updated vehicle paperwork. Or you have every right to deny responsibility, and the court will commence your trial forthwith. What do you wish the court to do?
I have my proof of insurance and updated plates.
Okay. The court is trying to establish as a factual basis what the status of the plate and the insurance were on the date of the traffic stop. So the court would need to establish that record first, and then we can talk about what remediation you might have done. So as to the date in question, were you operating a vehicle in the city of Berkeley with an expired tag and no proof of insurance?
Yes.
Thank you. The court accepts your plea. If you have those documents, to hold them up one at a time. Can you bring that in a little closer and say your name?
Christina Tomlinson.
Okay. I see the birthday. So there goes the expired plate. If you have a proof of insurance, that would be great.
And then
All right. Motion to dismiss is granted. These are both one. That cat wants breakfast.
yes, she does.
The court has to ask, what's up with the dummy on your left?
Oh, it is. So I collect movie props, and it is a costume from the movie Zathura.
Zathura is one of my son's favorites.
Yeah, that is Dak Shepard's costume from the movie.
That's terrific. They actually made a board game out of that we still break out every now and again. All right,
It's
Ms.
pretty
Tomlinson.
fun. We have it too.
Good luck to you. Take care.
Thank you very much.
Bye-bye.
Sadly, Ellie was not present for that cat. She's ran off somewhere. Good morning, everybody. Happy Tuesday. This is TCF Live. My name is Dan. 35 of you here already. Good morning. If you haven't yet said good morning, if you're new to the channel, take a moment and introduce yourself. Say hi in the chat. We're friendly folk around here. It is a slower start off in Courtlandia at the moment, but Judge Middleton has some stuff going on, so let's check in with him.
184 OD. This is an ordinance case. Are you Felicia K. Keith?
Mm-hmm. Yeah.
Yes. All right. Well, nothing terrible is going to happen here, so it won't be that bad. This is Rhonda Ives. She's one of our public defenders, and she's here sitting in for our normal public defenders, and I appreciate her being here. Miss Keith, you got a ticket in 3 hours at 1:04 a.m. at US 131 in Broadway, about 16 miles from where the last guy got stopped. They say that you were operating under the influence of alcohol. They did a blood draw. We don't have your blood result back yet. So I'm going to make the same recommendation to you that I did to him, that you plead not guilty and I get a lawyer to help you with this. You also have a previous offense, which could make this a second offense. So your case is very similar to his. I saw Barb back there. When were you a Kinney?
When I was adopted.
Okay, got it. She's been here a lot of times with a lot of kids that she's helped. No contest. But plead not guilty. Appoint an attorney. That attorney pretrial for 8/7/26 at 8:30. Your other case is too old to charge as a second offense. You have to have 2 OUILs within 7 years. And that one was in 2017. So it's charged as operating while intoxicated, first offense. But we don't even know all the facts yet. They have to get your blood back from the State Police Crime Laboratory to see what level it was at. So it's prudent to plead not guilty. So I'm going to give you the same advice. I want you to call your lawyer and make an appointment to discuss this with him prior to August 7th. They'll get the lab report, get the police reports, their body camera, that sort of thing, and then be in a position to discuss it with you. So you go with the court officer and I'll see you right here, August 7th at 8:30.
Okay.
Just a minute.
Okay.
Thank you, Mark.
It'll be on the paper.
And,
Okay.
I locked it because it was fuzzy. Now you can see everybody. All right, sorry about that. Let's talk to Jace Mobley. Good morning, sir. Are you Jace Michael Mobley?
Yes.
I have the camera locked. All right, Mr. Mobley, you're charged with driving suspended second offense. Let's take a look at your circumstance. This allegedly occurred on June 13th at US 131. Everything's happened on 131 today. That's Super 8 Way, right? Basically in front of Myers at 9:30 at night. Driving suspended second offense is a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. Carries 2 points on your driving record and it requires your license to be suspended. Let's take a look at your driving record. Thank you so much. How many of these are there? I have 9. Are these bench warrants?
Yes, the only one that's technically not a bench warrant is the
Oh, gee whiz. It had to be 9 bench warrant arraignments on an already very busy morning.
Nothing we can't handle.
Yes. Mr. Mobley, I don't see your previous driving suspended charge.
I've never had one under what I understand. I've never had another suspension.
You've got a lot of baggage on your driving record, and they wrote this as a second offense, and I don't see that it is a second offense. Maybe they know something I don't. Well, I guess at this point, my recommendation would be that you plead not guilty because I don't see that you have a previous suspension. You don't believe that you do either? I can't believe they just gave me 9 bench warrant arraignments. Have you done anything to try to get your license back?
I didn't know it was suspended.
What?
I didn't know it was suspended to begin with. Because I had a ticket that I paid for and paid all the fines, but I'd never got anything stating that my license was getting taken away.
They said a driver assessment examination, and you failed to appear on March 31st of 2026 because you had 3 negligent crashes, and you were suspended from April 5th until you got straightened out. So you got suspended as of April 5th. Do you still live at 960 West Chicago Road, Lot 11?
Yes.
Well, the Secretary of State would have sent you a letter. They set you for a hearing in March, and you didn't show up for the hearing. So they suspended you in April indefinitely till you get a hold of them. So there's a couple issues. One, you're a second offender. 2, you gotta get a hold of the Driver License Appeal Division and figure out what you need to do. You had a crash in November of 25. You had a crash in August of 24. You had a crash in July of 24. And so a state trooper or somebody referred you for a re-exam and you didn't show up for it. I think you could use some legal help. I would recommend that you go to the Secretary of State office in Sturgis. You start there. You might need to make an appointment. That isn't where it's going to end. You got work to do with the Driver License Appeal Division. They set up a hearing because you had 3 crashes in about 16 months. You didn't show up for the hearing.
Like I said, I never got anything.
Well, I'm sure they must have sent you something. They don't just do it and then tell you about it later. They send the notice to the address that's on your driving record. But right now you can't drive.
No.
Set attorney pretrial for 8/7/26. Debbie, are you handling that immigration motion this morning also?
Yes, it's not till 10:30.
10:30.
Right, yes.
So are you with me all morning?
Yes.
All right. What we got to do here. All right, Mr. Mobley, I think you could use some legal advice. I'm going to get an attorney to assist you with this. Are you missing work right now?
No, I'm off for 2 weeks.
Well, I'm going to set this for August 7th. I want you to do some work between now and August 7th. I want you to go to the Secretary of State's office, find out what you got to do, try to get your license reinstated.
Thank you.
All right, I'll see you then.
Good morning once again, everybody. It is TCF Live on a Tuesday, the last day of June already. Where is this year going? I have no idea. Couple of courts starting to boot up now, but we're going to continue to ride with Middleton for just a little while longer.
Then we'll see Gina Huser. Yep. All right, thanks. Bye. All right, Debbie, maybe we can slip a couple of these in before we start pre-exams. Jordan, what's going to happen with your case?
I believe we're going to be requesting a competency exam based on.
Who's your client?
Angela Lockery.
Okay.
She's got 3 files up today.
Is she in custody? Rhonda, do you know what's gonna happen with your one case?
I don't know. I'm forwarding, I had been communicating with Gary and Angelica, just forwarded an email to Miss Davis for her to review.
All right, well, let's finish our arraignments. Scott Ray Rudisil is not here on a driving suspended charge. It's his first fail to appear. There's a civil
Improper
infractions,
transport, right?
no proof of insurance and no plate, driving while poor. Mr. Rudisil is not here. Try order to show cause first. Shayna is the bearer of bad news. It's not her fault. Under the old system, I would, when I got in each morning, I'd look and see who got arrested overnight. We're not there yet. I do get a copy of the jail roster, but I didn't get it till I was on the bench. So these people all got arrested last night. Rhonda, stick with me. I try to do these when I have a public defender for these bench warrant arraignments. I don't believe I have anybody else here for misdemeanor pretrials. Mr. George, Gina Huser got picked up. She has multiple trespasses.
I think she's represented by John Bush, Your Honor.
Yes,
That
she
was
is.
up
She
for,
is.
Free trial, I think, last week.
She didn't show up. All right. I don't want to stick it all the way out till August 7th. Maybe I'll put it on Judge Patterson's docket. I guess it isn't as bad as I thought. It's a bunch of cases, but only 2 people.
All right, well, we may check back in with Judge Middleton in a little while, but Hammer points out in the chat that wonders if McNally will stream after yesterday's incident. All the channel's videos were deleted yesterday. That is not the first time that McNally has purged his channel. He's done it before. And honestly, I think the reason that he purged it yesterday was because he wanted to do a little bit of damage control because he was screaming at somebody. However, it got out there. This channel has that entire hearing as a standalone video. But to answer your question, Hammer, he is back, and we're going there now. Say good morning to Judge McNally.
Thank you so much.
Can he pay all of this today, or does
He cannot, Judge.
how much does he have?
4 months.
I want to set you on a payment plan. You make $700 to $900 per week. How much can you afford to pay weekly? I don't even need that. We'll make it $65 a week. You get paid every Friday? I'll make it starting on July the 6th, okay?
Thank you, Judge.
And the Monday, each Monday thereafter until paid in full. If you don't have the money, it's not a problem. You call the court, we'll go through Zoom, or you can walk in here on or before any due date at 8:30, and I'll be happy to give you an extension. Do you understand that?
Yes.
Okay.
Thank you, Judge.
You'll meet with probation. Good luck. Thank you. People Against Priority Waste, 2-6 SO25034. Good morning. Your appearance, Ms. Tremblay.
Yes, good morning, Your Honor. Elizabeth Trombley appearing on behalf of Priority Waste.
How are you today? Good?
I'm good. How are you doing?
Not too bad. You're going to plead to overweight. You're authorized to enter this plea on behalf of the company with agreed upon fines and costs of $1,000, correct?
Correct, Your Honor.
Is that charge of overweight responsible or not responsible?
Responsible.
Plea is accepted. Fines cost of $1,000. Pay by July 30th. Have a great day. Thank you.
Thank you too. Thanks.
Danielle Chantee Mosby, 26M692120. Okay. Ms. Mosby and Trooper Brown, I need you to start your videos and state your name, please. There you go, Trooper. Good morning. Your name?
Good morning. I'm
Please.
sorry.
Okay, hang on. Wait, come on back, Ms. Mosby. Unmute now.
Yes,
And
Your Honor.
tell me your name, ma'am.
My name is Danielle Mosby.
Good morning to you. Can you just stop walking, find a place, please?
Yes, sir. I'm getting to the table right now.
Trooper, your name?
Trooper Brown, Michigan State Police.
All right. Is there any offer on this, Trooper?
If Miss Mosby's record allows, and
I'm going to give you what
being
her
polite.
record shows. She had an operating while impaired in 2025. And then there were license sanctions, and then she had an implied consent refusal on that. So she was suspended between February of 25 and February of 26. Other than that, it does not appear as though she has anything else on her record.
Would be open to offer impeding traffic if the courts would be okay with it.
You want to plead to impeding traffic, Ms. Mosby?
Is that a lesser than what I had?
That's 0 points and it won't go on your record. 75 and a 70 is 0 points, but it would go on your record.
Yes. Yes, Your Honor.
You want to plead to impeding?
Yes, Your Honor.
All right, to that charge, responsible or not responsible?
Responsible.
All right, so with what you have, that's a nice offer of him. I'm going to accept the plea 170. You can go online and pay that today, okay, ma'am?
Yes, Your Honor. Is it possible? I'm unemployed right now.
When can you pay it? Just tell me when you can pay it.
Is there like a payment plan I can get on?
Tell me when you can pay it, ma'am.
I could pay like $15 right now. I live in Detroit. I travel.
I know. Just listen to me. When do you think you can pay this in full?
170. Can you give me like 3 months?
Ooh. Well, you're asking for a lot, but I'll tell you what, I'll have you pay $25 bi-weekly.
Okay.
Bi-weekly. So every other week, and I'm going to start this beginning on July the 17th, okay?
Yes,
Now,
ma'am.
if you don't have the money on any one of those dates, you call the court, request an extension. I'll go on Zoom with you, or you can show up here at 8:30 in the morning, whatever's easier for you, and I'll be happy to give you an extension, okay?
Yes, Your Honor. I appreciate it.
Just don't ignore me, though. You understand what I'm telling you?
I understand, Your Honor.
Have a great day. Good luck to you.
Thank you.
Nicholas William Blum, 26M6 Trooper, your appearance again, please.
Trooper Brown, Michigan State Police.
Mr. Blum, your name?
Good morning, Your Honor. Nicholas Blum.
So, he has nothing on his record. So do you want to offer impeding?
Yes, Your Honor.
You want to plead to impeding, Mr. Blum?
Yes, Your Honor.
Sorry, it's Blum, right? You said?
That's correct.
Okay, Mr. Blum, to the charge of impeding traffic, which is 0 points, it won't go on your record, responsible or not responsible?
Responsible, Your Honor.
Got nothing on there at all. 150 is your total. You can go online and pay that. You're all set, okay?
Thank you, Trooper. Thank you, Your Honor.
Good luck. Thank you. Deputy Wade Bryant, 26 M694801. Mr. Bryant, you have to, there you go. Unmute and tell me your name, sir. Mr. Bryant, you have to unmute bottom left-hand corner of your screen and tell me your name, please. There you go.
Bryant.
Say it again because I only caught Bryant.
Jesse Bryant.
Your name again, Trooper?
Trooper Brown,
Jesse
Michigan State
Bryant.
Police.
Oh,
All right. I have an August 05 operating while impaired out of this court. I have a November 17 operating while impaired out of Dearborn Heights, a 23 speeding, and a 24 speeding. He's charged with 85 and a 70. What do you wish to offer, if anything, here?
You willing to offer 1 to 5 over, Your Honor?
Yeah, that's what you, oh, okay, you wrote him for 11 to 15. So if you plead to 1 to 5 over, sir, that's 0 points, but it will be added to your traffic record. Do you understand that?
Yeah, I understand.
You want to plead to 75 and a 70, or do you want to go to hearing on the charge of 85 and a 70, which would be a 2-point violation?
I'll do the first one.
So you plead to 75 and a 70, limited access?
Correct.
Do that charge, responsible or not responsible?
Responsible.
All right, you got to slow down, sir. I'll accept the plea. 190 is your total. You can go on 33court.com right now and make your payment, okay?
Okay, thank you.
And you have the money to do that, right?
Yes.
Good luck. Thank you. Junior Finke, Junior Santonio Finke, 26M6921112. I have a B and a C file here.
Judge, he paid the A case.
Oh, he did? Okay, where's Mr. Finke at? Mr. Finke, state your name, please.
Hello, Your Honor. I am Junior Finke.
So he paid already. You charged him with 5 over, limited access, 75 and a 70 on I-75. He paid that one. And then he's got an expired plate and a no proof of insurance charge. The only thing he has on his record is a case from 2000. No, that's the only citation he has, is the one that he paid. So what do you want to do here?
You willing to dismiss the no proof of insurance if he takes the expired plate?
Do you have valid insurance now, Mr. Finke?
I do, and my plates are also valid, Your Honor.
Okay, so he's offering, if you plead the expired plate, he'll dismiss the no proof of insurance.
I will.
You want to do that?
Yes, Your Honor. I was at fault. I'll take whatever is given to me.
To the charge of expired plate, responsible or not responsible?
Responsible.
All right, I'll accept the plea to expired plate. He's dismissing the no proof of insurance. That case is dismissed. 135 is your total. That's on the B file, expired plate. And I'm dismissing the C file, no proof of insurance. You can go online and pay that at 33court.com, okay?
Your Honor, thank you.
Have a good day. Thanks. Oh, you got another one, McGee. Delicia, Lachey, McGee, 26M6922200. All right.
Judge, I don't have her on Zoom.
Oh, she's not here. Trooper, your name?
Trooper Brown, Michigan State Police.
She didn't show up. She was given 15 minutes. This was scheduled for 8:45. It is now 9:18. Defendant is responsible as charged by default. So I will go ahead and enter that judgment. And I think that's it for you, correct? Oh, you got
He
more?
has more.
Should have 3 more.
What time are those scheduled?
9 o'clock from my understanding.
Good. Well, it's after 9:15, so we can call those down. Samantha Tercek, 26M70744. Ma'am, you have to start your video and state your name, please.
Oh, hang on 1 second. Sorry. Why did this not work?
You're good now.
Oh, I'm good. Okay. Hi, Samantha Tercek.
All right, she's got a clean record. What do you want to do on this one? Operating while texting.
I was
If she has, oh, sorry, go ahead.
Go ahead.
If she has a clean record, I'd be okay with impeding traffic so it's not on her driving itinerary.
Ma'am, were you using your handheld device? Why are you doing that? I hate that. I see people going all over the road. I sometimes think that's as bad as drunk driving, if not worse.
I'm not going to do it again. I was on the phone. I was actually texting a patient, and I won't do it again, sir.
What do you do for a living?
I'm an RN. I'm a home care RN, and I shouldn't have been on my phone or texting. So I apologize, and I won't do it again.
Nice to see somebody admit they're wrong.
Yeah.
All right. You want to plead to impeding?
Yes, please.
Just saved yourself about $15.
Okay, thank you.
Deducted yourself. Did the charge impeding responsible or not responsible?
Responsible.
Please accepted 185. You can go online and pay that, okay?
Thank
Good
you.
luck. Thank you. Caleb Partial Richmond, 26M708027. Yep, he should be here. Caleb Richmond. Come on in, Mr. Richmond, please.
Good morning.
I done now?
Your name, sir?
Caleb Richmond.
Right. Let's see. He's got nothing on here, Trooper. He's got just 75 in his, nothing on his record at all. You charged him with, it was 75 and a 70 limited access. What do you want to do on this one? Oh, you're muted. There you go.
I would be willing to offer impeding traffic for him. I remember he was respectful.
0 points won't go on your record, Mr. Richmond. You want to do that?
Can you repeat that?
He's offering you to plead to impeding traffic. You can either plead to impeding, that's 0 points. It won't go on your record. I'm going to fine you. Or you can go to hearing on the 75 and a 70. If you lose, that's still 0 points, but it would go on your traffic record.
I can plead guilty.
You want to plead to impeding?
Yes.
The charge of impeding traffic, responsible or not responsible? You plead responsible, sir?
Yes, sir.
I'll accept the plea, dismiss the speed. 150 is your total. You're all set. Have a good day.
Episode 322 of TCF Live on this lovely last day of June. Let's head down to Florida, do our daily check-in with Wade Mercer.
Good morning. You're here because, as I told you yesterday, there's a violation of state probation warrant. And we didn't even make an attempt. I didn't make an attempt to try to resolve the underlying misdemeanor, did I?
I know the underlying misdemeanor was for driving with a suspended license, but when it was brought to my attention, I looked up his driver's license, and he actually does have a valid license now. It's not the sole basis for the VOP, but that's one of the 3 or 4 that he had for the violations.
What's your plan on that charge? Do you want to make him an offer to try to resolve the charge while he's here, or do you want to set it for pretrial, or do something different?
I'm trying to think, because
I don't know what the offer was going to be yesterday. I can't.
Yeah, 30 days is what it was going to be.
So, Mr. McDaniel, is there a desire to resolve that charge, or be just arraign him on the VOP?
Just arraign him and put him on the August 12th.
Negative.
Mr. Bauer, would you like to have an attorney appointed to represent you in the violation of probation?
Yes, sir. I did not ask to have him appointed. There is a desire to try to resolve that charge. The other violations of probation, the issues were the payment, and the payments are also complete. And I've also, I'm working on the community service, which is the other technical violation.
Okay, so one step at a time. I'm going to appoint the public defender's office to represent you. Listen to Mr. McDaniel, then we'll come back to the charge, and I'll tell you what's going on in the misdemeanor case or the criminal traffic case. Mr. McDaniel, his court date will be when?
So you want me to deal with the misdemeanor or the felony?
I want you to go ahead and we're going to arraign him on the felony because he wants to talk about the misdemeanor. It seems like he says he's interested in resolving it. So I want to talk to him about that after we get him arraigned on the felony.
So I'm going to plead not guilty on the felony VOP. Next court date is August 6th, and there'll be an attorney come by and visit him and talk to him prior to that hearing. They may get it resolved before then, but I can't promise you that.
Thank you. So you've got no bond till August 6th at least. That's because that's what Judge Garcia has done in the violation of probation case. The offer in the criminal traffic new charge is 30 days in jail. That was the offer before we even knew about the violation of probation. So you said you wanted to try to resolve it. That's up to you. If you want to wait and let Mr. McDaniel work on it, which seems to be what he's recommending, that's fine too. Give you time to talk to him. If you want to resolve it today, the offer's 30 days in jail. But as I said, I think Mr. McDaniel's plan is he'd like to talk to you more detail about that. You okay with waiting and talking to him, Mr. Bauer?
Yes.
Okay. So you'll see Judge Garcia on that date, and then I'll see you on the court date in the misdemeanor case, if not before then. If you decide that you want to take that offer and go ahead and serve that sentence while you're waiting on the VOP date, Mr. McDaniel may bring you up earlier, and I may see you in an upcoming first appearance, okay?
Okay. Today is the 6th?
August 6th.
August 6th is the next violation of probation date. Yes, sir. You just missed the cutoff for the July date, so the next one is August 6th. Mr. Williams?
You put him on the August 12th, Don, that would probably, I think it'll be gone away by, hopefully the VOP be taken care of.
We'll probably resolve it on the 6th. So if that's the case, we'll take them off the 12th.
Thank you. Any other questions, Mr. Bauer?
No, sir.
Have a good day, sir. We have Robert Clements. Mr. Clements, good morning. Mr. Clements, you're here because you've been accused of 2 new charges. They are trafficking in methamphetamine and introduction of contraband into a correctional facility. Mr. Clements, there is probable cause for both of these charges. You're already out on bond in case 25534 CF, and I believe that charge was sell of methamphetamine, I think.
It was, Your Honor.
So, Mr. Clements, there is probable cause on the new charges. I think you're entitled to a bond in the new charges, but you're not entitled to a bond in the violation of what appears to be a violation of your bond. So first thing I'm going to do is I'm going to revoke your bond in case 25-534 CF. That's based upon your new arrest. So even though I'm about to set your bond in the new cases, don't try to post it because you wouldn't get out anyway because I've revoked your bond in the case you were already out on bond in. In that case, I'm asking Mr. Mitchell to send me an order of revoking your bond in 534 CF. On the new cases, you're entitled to a bond in those cases, as far as I can tell. I'm going to listen to the attorneys and then I'll set that bond. Mr. McDaniel, anything?
Nothing, Your Honor.
Mr. Clements, Mr. Mitchell.
If for some reason he is able to post bond in the future, we just request that he be subject to random UAs on the new law charges.
Thank you. Mr. Clements, your bond on the trafficking methamphetamine, that's a first degree felony with certain minimum mandatory terms required if you're convicted of that. Your bond in that case will be $75,000 because you're already out on bond. Your bond in the contraband case will be $25,000. Your total bond today is $100,000 cash or surety with a condition of random urinalysis. But as I mentioned, don't try to post it because you wouldn't get out anyway because you got no bond in the other case. Mr. Clements, that's where things stand right now. Do you have any questions, sir?
No.
Have a good day. We have Michael Chaffin.
Yes, sir. Yes, Your Honor.
Mr. Chaffin, good morning. Mr. Chaffin, the paperwork I've been provided says that you posted bond in your Jackson County charges and you have a pending warrant out of Gadsden County in case 25375 MM. You're accused of violation of an injunction there, and the warrant does not have a bond on the warrant. What that means, Mr. Chaffin, is you'll go to Gadsden County. When you get to Gadsden County, you'll go before a local judge, and that judge will determine if you're entitled to a bond. There's no bond on the warrant. That doesn't mean you don't get a bond. It means you don't get a bond until you get back there. You may or may not get one when you get there, depending upon your circumstances. Do you have any questions?
How do I not go back to Gadsden County?
And there's no way for you to avoid going to.
I honestly, Your Honor, with all due respect, I have legitimate reasons to fear for my own well-being in that county.
So you're going to Gadsden County unless that judge over there changes her mind, the one that signed the warrant. So you may want to try to file something to try to stop the transfer. Otherwise, you're going back to Gadsden County in the next couple of days. Mr. McDaniel, anything else from the public defender's office this morning?
No, Your Honor.
Mr. Mitchell from the state?
Nothing from the state, Your Honor.
Quick morning in Judge Mercer's courtroom. Let's go up to Michigan. Haven't been here in a while. District Court in Pontiac. This is Judge Bowie.
These people still in Michigan arrested Delicia, Winnie Orlando, appearance director.
Morning, Your Honor. Laura Camacho, on behalf of the people.
Irene Wassel on behalf of Ms. Orlando, Your Honor.
No state your name for the record again.
Melissa Winnie Orlando.
So just to finish out the arraignment, because I didn't, it's a $500 personal bond, no driving without a valid license, registration, insurance, and we'll use today as a pre-trial. So how are we proceeding with this?
Your Honor, she is willing to take the civil infraction of impeding traffic with 0 points and not on her record.
Okay, so she has the impeding traffic, and then she also has a show cause for 6
Yeah.
to 10. No, okay.
Yes, Your Honor. She's been very ill. At one point, she was in a coma. She's in and out of the hospital during the year, and she tells me she can't walk. She's applying for disability.
So we'll give her some time to take care of that. All right, Ms. Orlando, if you can, please raise your right hand. Do you swear or affirm, subject to the pains and penalties of perjury, testimony give the court will be the truth, the whole truth, and nothing but the truth?
I do.
You may put your right hand down. Are you admitting responsibility in impeding traffic in the city of Pontiac on November 4th, 2021?
Really? Yes.
So that's a civil infraction fine of $175. It will not be any points in your license, will not abstract to your driving record. And you also have a $198 ticket, so altogether you owe about $363. Let me make sure that's right. Yeah, you owe $373. So I can give you 90 days to have all this paid, okay?
Okay.
So we'll set, let's do this. For the 175, we'll break it up. Have that paid by 7/31/26. And then if that's not paid, then I gotta see you back on 90 days from now, so September, and give you a date.
All right. Thank you, Your Honor.
September 29th, so you're all set.
All right. Thank you. Do I exit? I don't know what to do. I'm sorry.
You can exit, ma'am.
Okay.
Good luck.
With Kristen Leo, did you need to speak with, Kristen Leo?
No.
State 050 as some people state of Michigan versus Christian John Leo appears to the record.
Your Honor, the record should be up with people.
Good morning, Your Honor. Irene Wassel on behalf of Mr. Leo.
Mr. Leo, good morning. Please state your name for the record.
Christian John Leo, Your Honor. Good morning.
So we're here for a pre-trial. How we proceed?
My client wishes to plead guilty, Your Honor. He's been sentenced by Judge Anderson to 19 months to 6 years in prison. We'd asked for the immediate sentencing with concurrent sentencing.
Mr. Christian, please raise your right hand. Mr. Leo, I'm sorry. Do you swear or affirm, subject to the pains and penalties of perjury, testimony give this court to be the truth, the whole truth, and nothing but truth?
I do, Your Honor.
Put your right hand down. You do have a right to a trial by jury on this charge of malicious use of telecommunication services. Do you understand?
Yes, Your Honor.
Jury will be composed of 7 people that live here in the city of Pontiac. They'll be randomly selected by your attorney and the prosecutor through a process called voir dire. Do you understand?
Yes, Your Honor.
Okay, and at the end of that process is the prosecution's burden of proving you guilty beyond a reasonable doubt of this charge. Do you understand?
Yes.
Trial, you do have a Fifth Amendment right to remain silent. You don't have to testify at trial. You do not have to present a defense at trial. Your silence at trial cannot be used as guilt against you. Do you understand?
Yes, Your Honor.
You may waive your right. You may testify at your own trial. You may present a defense. You're not required, and no one can force you. Do you understand?
Yes, Your Honor.
Right at the end of your trial, we'll dismiss the jurors. 6 are going to deliberate. The 6 jurors must return a unanimous verdict of guilty or not guilty. Do you understand?
Yes, Your Honor.
Can't reach a unanimous verdict, the court will declare a mistrial, at which time the prosecution has the right to try the case again, or they may choose not to. Do you understand?
Yes, Your Honor.
And you do have a right to see, hear, and question all witnesses in open court against you. Do you understand?
Yes, Your Honor.
Any witnesses you wish to come testify on your behalf in your defense at trial, this court will sign subpoenas to order the presence of your witnesses. Do you understand?
Yes, Your Honor.
Your Fifth Amendment right to remain silent at trial. Do you understand that right?
I do.
Questions about that right?
No.
All right, as you sit here now, you're still presumed innocent until proven guilty beyond a reasonable doubt. Do you understand?
Yes, Your Honor.
All right, so you're going to plead as charged in this matter. Is anyone promising you anything? Is anyone threatening you? Or is anyone forcing you to waive your right to go to trial?
No, Your Honor.
You're currently on probation or parole?
No, Your Honor.
Citizen or a legal resident of the United States of America?
I am a citizen, Your Honor.
Final question is, you're entering this guilty plea knowingly, intelligently, and voluntarily. Do you understand the consequences of what you're doing?
Yes, Your Honor.
And I meant to say you're pleading as charged.
Yes, Your Honor.
So, factual base for the plea date of offense is March 29, 2026.
Mr. Leo, directing your attention to March 29, 2026. On that day, were you located at the Oakland County Jail at 1201 Telegraph Road
Yes.
in the city of Pontiac, right?
Yes.
And on that day, did you use one of the jail phones, telephone?
Yes.
And you spoke to another individual on that phone, correct?
Correct.
And during the course of your communications with that third-party individual, you made threatening statements regarding a deputy, Andy Waleed. Is that correct?
Yes.
You intended to threaten, intimidate, harass, annoy, or disturb the peace of Deputy Andy Waleed by making those comments, correct?
Yes.
And directing your attention to April 13, 2026, while present at the Oakland County Jail, again, you used a jail telephone at that time, correct?
Yes.
And you spoke to a third-party individual, and you made threatening comments regarding a Deputy Kathleen Schneider. Is that correct?
Yes.
And the comments that you made were threatening in nature. Is that correct?
Yes.
You threatened physical harm or damage to Deputy Kathleen Schneider or her property, correct?
Correct.
And you made these statements with the intent to terrorize, threaten, intimidate, threaten, harass, annoy, or disturb the peace of Deputy Kathleen Schneider. Is that correct?
Correct.
Clear, satisfied.
I'm satisfied, Your Honor.
Court is satisfied with the factual basis of the plea that was entered into knowingly, intelligently, and voluntarily by Mr. Leo. He understood the consequences of entering the plea is not disclosed anyone on the record threatening him, promising, or forcing him to waive his right for the trial. So we'll enter a guilty plea as charged. There is no objection, can immediate sentence.
No objection.
Any objection, Ms. Wassel?
Just, Your Honor, he is going to be sent to MDOC as soon as this case is over. He's doing 19 months to 6 years at MDOC. We'd ask for it to run concurrent.
I think there's no objection to the immediate sentencing. All right, you like to say anything, Mr. Leo, before we impose sentence?
I just wanted to apologize to the court for having to waste their time on this. During the time that I made these phone calls, I wasn't doing well mentally. As of April 16th, I started new medication. I seen psych, and I've got my way better control under my mood swings and such as that type of stuff. I feel like I'm doing a lot better. I sincerely regret the things I said. I was just upset and angry running my mouth. I regret what I said. I didn't mean it. I was running my mouth being stupid, Your Honor. And I'm sorry for what I did.
People, you think I have people?
Your Honor, I would just ask that the court sentence the defendant to a term of jail, again, with concurrent to the MDOC sentence.
Okay. All right. He's been in 36 days, so we'll give him 36 days of credit for 36 days served. We'll waive the fines and costs, so the case is closed as he's headed to MDOC for a prison sentence. So,
thank you, Your Honor. You're all done with this case, sir.
Yeah.
So it's concurrent with MDOC?
It's time served.
Oh, thank you, Your Honor. I really appreciate it so much. I'm very sorry again, and I'm sorry for the prosecution for wasting your time as well. Thank you, Ms. Wassell. I appreciate your time.
Thank you.
All right, take care, Mr. Leon.
Thank you. You too.
Well, the dude is nice. He's considerate of others. You got to give him that. Hopefully he gets through his MDOC sentence and comes out better on the other side. Fingers crossed on that one. That's definitely not a given. Good morning once again, everybody. About to enter hour 2 of TCF Live on this last day of June. I'm so sad because I live in the desert, which means we're about to enter like the Satan's oven portion of the summer, so that'll be super neat. Not that we haven't already had it, but it's going to get worse. Let's do this. Let's go back to Judge McNally. Check back in with him.
Hussein Al-Saraf.
We're adjourning this 2 weeks so you can get a license.
Yep, sounds good.
July 14th, what time, Lisa?
Any time works for me.
Well, good, thank you.
No.
I was asking my judicial clerk, but we do want to
9:45.
accommodate all participants here.
Okay.
Okay, go ahead. Go ahead.
9:45.
Okay. 9:45.
9:45.
Okay. Good
Okay.
luck to you. We'll see you then. Thank you.
Okay, thank you, Your Honor.
All right. Have a good day. People against Griffer. Ryan Joseph Griffer, 26B711925.
Good morning, Judge and staff. John Graziani, I bring on behalf of Ryan Griffer, who is to my left. Please identify yourself, sir. Ryan Joseph Griffer. We're seeking a 1-week adjournment, Judge.
Lisa, who is sitting for me then?
Judge Hessen is handling all PCCs.
Yeah, so I'm not gonna be here. So I'll tell you what I'll do. Can you call it, is Ms. Holloway?
There's a bit of an issue, Judge.
No, I get it. Call Ms. Holloway a second. I could adjourn the final pretrial to July the 14th. Here's what I'm thinking. And then set the trial for the following.
That would be great, Judge.
Let me just check and make sure she doesn't have any conflict with witnesses or anything like that, okay?
Absolutely.
So I'm gonna ask her, conference room is she? I didn't get a sheet.
I just called her. I didn't get a sheet either, but she's on her way.
Did I ask your name, sir?
Yes.
Okay. Just give us 1 second here.
Morning, Your Honor.
I thought Ms. Holloway was on this one.
Yeah, Miss Holloway.
Yeah, what conference room is she in?
Mine. Yeah.
She's in the
I don't even know where she's.
I don't go get her. She's in the room
Is
across
she
the
in
hall.
two?
She's in the room across the hall to me.
Yeah, Ms. Esmeralda, I don't need you on this. This is a domestic. I just want to make sure.
I was gonna say, I haven't talked to Attorney Graziani in the case yet.
What's that?
Talk to Attorney Graziani.
I'll be talking to you.
Yeah. What are we doing here? Can I have you sweetie tea, please? You.
She's on it.
I can go grab them.
Yeah,
Thank you
please.
so much. It works out well. Just to
How you doing, Ms. Holloway?
Yeah, the April 86528.
You didn't show up. What time did you show up today?
9.
What time we start our dockets?
I know.
It's okay. It's fine. Try to get early. I went. It's all right. I was impressed with this young lady trying her bench trial. I don't know if she did. Why are you shaking your head side to side? You did a very nice job.
Oh,
It's what?
tough trial.
Yeah, but she did a nice job on this. I was really impressed, Mr. Graziani.
That's why I don't want to go to trial.
I know, she's tough. She's gonna be a really good lawyer. I'm impressed. I'm not easily impressed
It's a
either.
good prosecutor's office.
Okay, so I'm thinking about taking he wants to adjourn the pretrial 1 week. I'm not gonna be here, so I'm gonna adjourn the pretrial 2 weeks and adjourn the bench trial from July the 14th until the 21st. I want to make sure that's not gonna create a problem for you.
That works.
Okay, so we'll make it July 14th at, we'll just make it at 9 o'clock. Bench trial on the 21st, Lisa,
At 1.
at 1. Okay? All right, I know what I said. You did a nice job. I was impressed. Good luck, sir. We'll see you here in a couple of weeks. Thank you. Lucas Bowman, 269, 709-278P.
Ready, Your Honor. Good morning. For the record, Trevor Garrison for Mr. Bowman. Your Honor, we're respectfully requesting an adjournment of the pre-hearing conference.
You guys can't, what are they doing here? It says pre-formal officer stated a case was submitted to prosecutor for misdemeanor charge.
Exactly. That's
What's
right.
Well, I mean, I'm not gonna wait for them to go through that. They either need to. I don't. Did you talk to the prosecutor about this, Mr. Garrison?
I did.
What is she saying? Have they submitted it? Are they going to authorize on some misdemeanor charge or what?
Well, I don't think she knew that it was that the civil infraction was dismissed. I told her that, and so that's another reason why we're requesting a postponement. I don't believe we'll be able to resolve the civil infraction anyway. They're indicating that they have no authority to dismiss it, given that my client had a CDL. A dismiss or amend. So it's likely it'll go to formal hearing.
Well, I'm gonna adjourn the formal hearing then. I'll set it for, we'll set a formal hearing. So you have to be in person though, okay? July the 14th at what time, Lisa?
Well,
I'm not gonna put this off much longer. I mean, I get it. I'm not saying I'm a fan of that law, but that's the policy they take, so.
No, I understand. I'm out of town on the 14th. Do you have any other days besides Tuesday? My Tuesdays are jammed for the next few weeks.
This is a state prosecutor and they're only in here on Tuesdays.
Okay.
I'll go to the 21st. That's the latest I'm going.
Well, I'm going to be in Bradenton, Florida anyway on that day. I'm sorry, Your Honor.
You said you weren't going to be here on the 14th.
Right, and I'm also gone the following week. I'm in Colorado on the 14th.
Are you really going to have a formal hearing on this? I mean, if I get guys telling me this, then they come in and plead, and I'm not gonna. I don't want to do that. I'm just telling you. If I'll go out of my way to set this later for you, if you're really going to have a hearing, but guys don't have hearings on these.
Well, I mean, my client, this is his livelihood. I mean, having a.
No, listen, I'm not, if you're gonna have a hearing, all you gotta do is, no, Judge, we're definitely going to a hearing.
Right. Well, I mean, yeah, we have some dash cam, and that's a decision I'll talk to my client about, but.
All they got is 70 to 65. I just can't adjourn it much longer, is all I'm trying to tell you.
I understand, Your Honor. Well, I mean,
What day can you do on a Tuesday? I'm not taking it to August. I promise you that.
Well, that was what I was going to suggest, August 18th, but.
No way. No.
Okay. Well, then,
I can do an afternoon for you. I'll do that for you. Where's your office at?
Royal Oak.
I can't go that long. What's wrong with, you're gonna be gone the week of July 14th and the week of July the 21st and the week of July the 28th?
No, not the 28th, but the first 2 weeks, yes. How about August 4th in the afternoon?
What's that?
Is August 4th in the afternoon?
Why can't you do the 28th?
I have a pretrial in Oakland County Circuit Court in person at 8:30, and then I have a Clinton Township matter at 1.
Call in the prosecutor, will you? And you're gone for 2 weeks on vacation or what?
No, the first week is well, kind of. The first week is a vacation for 3 days, and then the next week is a soccer camp in Bradenton, Florida.
Well, so I got it. You play soccer or your kid, you mean?
No, my daughter does.
I'm not going to August. I can tell you that. So you're gonna have to figure out something.
Well,
counsel your appearance.
Good morning, Your Honor. I'll say it's 9:30. People be 8:00.
I don't want to adjourn this forever. He wants me to set it for August 18th. I'm not going there. This is the civil infraction, 11 to 15 over, but they only wrote him for 5 over, right? They only wrote him for 5 over. This is.
Is that the one with $60?
Yes. Yes.
And you were already made aware that that question was dismissed because it was going to be submitted as a misdemeanor law. This.
Count 1 was, right?
Yes, not 2.
Right.
It's a CDL driver, but it's a CDL driver. I didn't let it, I can't use it anyways.
That's still limited access, right?
Does it say limited access on there? I don't.
It doesn't say limited access, but they never say limited access. This must have been, they wrote them for 70 and a 65 on I-75.
Yeah, they wrote it as exceeding speed limit. Those ones are tricky. They don't give us much room to do anything.
No, I know because of that masking law, which I don't know why they.
I don't want to get.
I'm not blaming the prosecutor's office. At first, I thought maybe it was them, but it's not. I read the masking statutes, and I don't know.
Well, if I have a strong opinion on that.
I don't.
I'll do.
I don't. Yeah, but I can't. She can't violate laws. She's not going to do that. They're not going to do that.
No, I understand. It's neither here nor there, I guess, but it's just I don't think it prohibits plea bargaining. It's just masking I think it's different, but that's for, I guess, another day.
You could reduce the charge to something similar. So non-moving violations can get reduced, but moving violations are not allowed to get reduced unless it's something similar. So if I had like an 11 to 15, I could reduce it to like a 6 to 10 or something.
And they only wrote him for 70 to 65. I'm not sure why the jacket, unless somebody made a mistake, Lisa, says 11 to 15 over.
It was a mistake. I can assure you, we have the dash cam. That was a mistake.
Well, wait a minute. Well, I'm saying an internal mistake by us because somebody put on the register 11 to 15 over. They only wrote him for 70 and a 65.
I did see that, yeah.
I don't know what the actual speed was. They usually put it on here. They didn't.
It said 70 and 65 right under the ticket, under the portion with the charge, under the count.
That's what they charge, 70 and 65.
Right, and exactly. And
but
then
hang on, but I don't see what the actual speed was, unless it's saying he was only going 70 to 65.
I believe it was going 70 to 65. Typically, when I see speeding tickets, sometimes they'll put 72 and a 65. The numbers will change. It doesn't stay to that 1 to 5 range. It doesn't stay to that 5 range.
Right.
I believe he was going 5 over.
I don't know what to tell you guys. I'm not adjourning this to August. So
all right, if you know what, I have another thought. If you're on it, could I join the breakout room again and I'll talk to the prosecutor? All right, thank you so much.
Yeah, sure.
Thank you.
Thank you.
Alrighty, friends, hour 2 of TCF Live. Happy Tuesday morning to all of you. Hi, Ellie. Ellie just came in to say hi. Have a seat. So Daddy can do the show. There we go. Okay, let's do this. Let's go to Texas. Check in with Judge West, just getting her day started.
Yeah, please just. Good morning. Are you August Maribel? And Mr. Maribel is charged With theft of property with previous convictions, there are 13 cases. Starting with cause number 26 DCCR 0347. Then we've got 0876, 77, 78, 79, 80, 81, 82, 83, 84, 85, 86, and 1029. And Mr. Parker, what is the announcement?
Your Honor, I've talked to him this morning and previously at the jail. He's indicated that his family's working on hiring his own lawyer, so he's requesting a reset to be able to hire his own lawyer.
So, Mr. Maribel, if I reset your case, it'll be about 30 days or so. Do you think they can get someone hired?
Yes.
So Mr. Parker remains your attorney, unless you get another attorney. And so he'll remain on your case, start looking through everything, visit with you about it. If someone else is hired, then they'll file a motion to substitute in and we'll get that taken care of. If for some reason they don't get someone hired, then when we come back next time, you'll need to be talking about what your options are with Mr. Parker, okay? All right, go back to the bailiff.
There's one other case that Life's representing.
Ellie, Barbara just gave you $5 for treats. Can you tell her thank you? Love up on her? Maybe a little? Well, I guess she's going to go shopping for those treats, maybe. Thank you, Barbara.
He has 4 previous cases and he has 2 new cases. And like Kelly put me on those, but Mr. Kimler says he's going to handle those as well.
Is that correct, Mr. Kimler?
Yes, sir.
So if you'll get a notice filed on, I only see one new case.
Well, all I have is 1 new case, but she told me 2. I may be totally wrong. I mean, I have.
Yeah.
It may be 1.
So, Mr. Smith, on Jeremiah Branch, I have a new offense of 26 DCCR 1168. Is there something else coming, or is that?
I think that was the new one, Judge.
Okay. I thought there may be 2. I may just.
So, your Jeremiah Branch?
Well, there's 26 DCCR 0958 and 26 DCCR 1168 are the 2 new cases.
I've got Mr. Kimler on one of those new cases, but not the Mr. Kimler.
Not the latest.
Yeah, I don't have.
1168 is the latest one. He was also indicted 3 weeks before that on a aggravated robbery.
1168 is what I don't have.
Yes, I have you right.
That's the one I'm. He's taking up under.
Okay, thank you. All right. So if you'll get a notice filed on that, Mr. Branch is charged with aggravated robbery, assault on a peace officer, robbery, and then the last one is another robbery allegation. What is the announcement?
He has a bond, I suppose. There's an MTRP.
Have you filed a motion for a bond, or what do you?
We're asking for a bond on the MTRP. MTRPs.
Did she print out the orders on those? Is that this?
Yes, ma'am.
Okay. So clause number 25 DCCR 1382, which is an assault on a peace officer, and 25 DCCR 1385, which is a robbery, are both motion to revoke probations. And there are no bonds currently set. Is that correct in those cases? And Mr. Kimler has filed a request that I set a bond in each of those cases. It's like there's been a first amended filed in each of these. So he was placed on probation February 3rd of 2026. In both cases is 10-year deferred probations, and the allegations are a new aggravated robbery from April of 2026, testing positive for cocaine on several occasions, failing to submit to drug or alcohol screening on several occasions, failed to comply with Texas Drug Education Program, a new offense of evading arrest or detention from February 6th, resisting arrest or transportation, February 6th. And so, Mr. Kimler, you may proceed.
Well, Your Honor, they're deferred adjudicated probations. We would just request to reach with MTRP bonds. If the bonds are denied, we would request a disposition on the MTRPs within 20 days and request for the bond pursuant to the code of criminal procedure.
Is there any evidence with regard to your client's ability to make a bond, or?
Well, Your Honor, I think he's entitled to a bond. I haven't filed a writ to challenge the amount of the bond because it hasn't been set yet. So I'll wait for the court to set the bond. If that's excessive, then I would follow.
If I'm going to set a bond, I need to have information on what his ability is so that I don't set one and then we're back in here.
I can elicit that.
Raise your right hand the best you can, please, sir. You swear affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
All right, go ahead.
Mr. Branch, please inform the court of your current financial situation.
I get $1,000 every month and disability.
And other than that, do you have any income?
I have food stamps, and I was gonna look for a part-time job too.
What is your disability that prevents you from working?
Seizures, but they told me I couldn't work like I could work like 3 to 4 hours a day.
Go supplement your.
Yeah.
Do you have any assets? You own your own car?
I don't own my own cars.
Are you under?
My mom gave me I'm not able to give me a ride.
Are they giving you medication at the jail?
Yeah, they just put me on the new medicine and it's been working good. Everybody on the dorm say I haven't been having seizures or outbursts.
What medication are you on?
I've been trying to get the name of it, but I try to ask my nurse the name of it this morning, but I was sleeping.
Are you functioning okay now?
Yeah, I'm functioning way better than now. I haven't, but when I got here, when they first booked me in, I had like, they definitely in the booking, the booking, the front booking for like 4 days. And I had like 5 seats.
If the judge grants you a bond and you're able to get out, would you follow up maybe as a condition of your probation or condition of your bond with MHMR?
Yes, sir.
To continue the treatment?
Yes, sir.
And as far as your other financial assets, you don't own your own car, do you rent, or where do you live?
I stay with my mom.
Okay. And your monthly expenses about what are these? As far as food?
She pays the bill and I'm on food stamp.
Password?
No questions, Judge.
It's for the record, I'm taking judicial notice of the court's files in all of the cases. And so give me just a second. I'm right now going over the probable cause affidavits and those 2 new offenses. Then I'm going to get to something else as well. Any witnesses, Mr. Smith, or just argument?
Just argument.
All right, give me just a second then.
I'll make it.
Yes, ma'am.
Almost there. Give me just a
second.
Also reviewing the pre-sentence report from the 2 cases where he was placed on probation as well in January of this year. But there was already information when he was placed on probation in January with regard to some mental health issues, and that was addressed. So he was placed on the mental health caseload. So it looks like that's not a new information, that he had some. Okay, Mr. Smith.
Judge, I understand that these are deferred cases, but the state is opposed to setting bond based on the nature of the crimes that he was on probation for and the nature of the crimes that he committed within 2 months of being placed on probation for these first robberies. He, on top of the 2 felonies that are filed, there's also evading and resisting that are pending in misdemeanor court. He has failed several drug tests. He's refused to take other drug tests, indicating to me that he is probably under the influence of illegal narcotics most of the time. And for those reasons, I believe he is a danger to our community, and I would request no bond in these cases.
I would just add, Your Honor, if the court refuses to set a bond, requesting us disposition within 20 days of their.
So here's what I'm going to do, Mr. Branch. So the underlying offense that you're on probation for is a robbery and an assault on a peace officer. And the robbery occurred at Delaware Food Mart, went in, attempting to steal, assaulted the clerk, and then they held you there while the police got there. And here we are 2 months after you got placed on probation, or 3 months after you got placed on probation for a robbery of a store. And we've got 2 additional robberies of the same store 3 days apart that are alleged. So obviously I agree with Mr. Smith. I think that you are a danger to our society. I am going to set bonds. I'm going to set bonds in each of your cases at $300,000. Conditions of those bonds, if you make them, are that you are on house arrest with a GPS monitoring device, and then we'll set your case for the appropriate hearing. Right.
Thank you.
Thank you. Both cases, 1382. No, this is on 25 DCCR 1382 and 1385, the 2 MTRPs. I didn't do anything on the others. There's the order. Sentencing on Ebony Broussard.
That was actually. That was actually.
Is Muffino here? All right, we need to wait for Miss Malfino. If we can just have her wait just a minute. LaAsia Clemens, Mr. Kimler. There's also Miss Malfino's.
Right. She's got others. She's ready. I know some others in this case.
Is Miss Holmes here?
She just went next door.
This is set for her trial.
So obviously the case that Mr. Kimler's on is the one that would be the one that is set in the pretrial, and the other one is a new evading arrest. Ma'am, are you LaAsia Clemens? And Ms. Clemens is charged with robbery and cause number 25 DCCR 1339. Excuse me, that case is set for trial to begin with jury selection next Monday. There is another case of evading arrest or detention with the use of a vehicle. I don't show that you've been hired on that one. Ms. Holmes represents her, but I would think that the robbery would be the issue we need to take care of first anyway. So
Judge, I have, if I may, spoken with Ms. Holmes about that case. also would appreciate the opportunity at this juncture to speak with Mr. Kimmler again about the original offer that she rejected now that she has been back in custody and has a new felony.
Let me
I
hold
don't
up.
know that might not dispose of everything. Otherwise, I will have an announcement here very shortly. for the
Okay,
court.
I'll hold it. Y'all visit real quick. And then we also have the sentencing on Ebony Broussard. Let's take care of that, and then y'all can talk on this Clemens. All right, you are Ebony Broussard?
Correct.
And
Yes.
this is cause numbers 19-32518, 19-32806, and 21-36615. Ms. Broussard is on probation in the 32518 and 32806, was put on probation January 21st of 2020. 10-year deferred probations. One was escape while arrested, and the other was the second-degree assault on a peace officer, and then was placed on probation July 12th of 2021 in the clause number 21-36615 for a 5-year deferred probation for a state jail felony offense of possession of a controlled substance. She was here previously, entered pleas of true to counts 1 through 5 in that motion to revoke in each of the cases. There was no agreement. I received the pre-sentence report update. Have y'all both had an opportunity to review that update?
I have, Judge.
Are there any additions or corrections or anything on that?
Judge, I have just a quick comment. I'd also like to ask Ms. Richard or Ms. Fenton if they have anything for the court. They've been very involved in this case.
Anything that's not in the report that you think is important?
No, Your Honor, everything that we have in there is very direct in support.
All right, thank you.
And my only position, Judge, would be that she's obviously been extended almost every opportunity that probation has, every class, every structure, every program, and it would not be the position of the state like it typically is to argue for safety. In fact, I would argue strongly against it.
All right, Mr. Kimmler.
I suppose, Your Honor, in response to that, she has demonstrated an ability to complete the programs, which is reflected in the pre-sentence report that she has been ordered to attend. Of course, there is a pattern of conduct that reflects addiction and substance abuse, but she also has the ability to complete the programs as well. I don't know how that relates to her inability, I suppose, to cope with the substance abuse issues, but she does have the ability at least to have enough structure and conform to the structure of these programs to complete them. So that says something. It looks from the pre-sentence report, it would be asking a lot to continue her on probation, especially with probation probably being unwilling to, or at least reticent to do that. I would only ask the court, if the court is considering the revoker, to consider something at the lower end. She does have children, and I'm not trying to use that as an excuse or anything, but they could maybe perhaps
Children she was on her way to get while she was under the influence of PCP.
I don't know that they established conclusively that she was under the influence. I mean, again, it reflects the substance abuse problem, but she does.
She played true to all of the counts.
Right. But yeah, that's true, Your Honor, and it reflects a continued struggle with substance abuse.
Yeah.
And so the issue then is going to be I'm looking probably incarceration, but I would just ask that it be something not extreme, or at the upper end. And she wanted to address it. What do you have to say?
I do take accountability for my actions, but however, I have completed ISL before. And if you will be willing to work with me again, I would appreciate it. I have, before I was incarcerated, I did enroll myself in outpatient classes, which was referred to me through Ozark when I got assessed. And I was taking AA classes as well. I did complete 5 of the classes. However, I wasn't able to complete it because I was incarcerated. I do still have my job, and I did complete my 5-year probation for the first conviction. And I do pay my.
So is the time It was told, I mean, because of the motion. So yeah, I mean, you did the 5 years, but
Yes,
it's
ma'am.
not over.
Yes, ma'am. I
still-
understand.
What is, Ms. Malfino, do you have any position with regard to specifically punishment on these cases?
Sorry, Judge, I was just thinking back of the original
Yeah.
PSI.
Yeah.
I do, thanks. Obviously, the court sees that she doesn't prior to this have any type of felony conviction, Judge, so I'll defer to whatever you think is appropriate, just in the context that they have given her so much of their efforts.
So, Ms. Broussard, you've been given the opportunity of, it looks like you went to Franklin North way back in 2017. And then you get on probation. You went through JCDI, but you couldn't complete it because of progressive sanctions for continuing to not follow those rules. Then you went to Franklin North, December 7th of 2020. You were on the drug patch program. You did that. You went to anger management. You went through the moral recognition therapy. You were on the high medium caseload. You've been to ISF. And despite all of that, you're still on 2 probations, one of which you could get 20 years in prison and the other 10. You still haven't figured out how to stop using drugs. And you were in fact in a vehicle going to pick up your young children from daycare under the influence of PCP.
Oh, man. However, when I went to Franklin North, it was because I was in a toxic relationship. And that's what the day did.
So, but here's, okay, how old?
And
How old are you?
I'm 42, man.
Okay, so you've been through what appears to be years of drug addiction. And at 42 years old, and you've been on these probations for 5 years or more, you've had every opportunity handed to you to try to help you, and you're still using. So at this time, in cause number 19-32518, I'm going to find counts 1 through 5 true, find sufficient evidence to find you guilty. And at this time, find you guilty of escape while arrested, sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 19-32806, find counts 1 through 5 true, find sufficient evidence to find you guilty, and at this time find you guilty of assault on a peace officer. Sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for the time that you've been in custody that the law gives you the right to receive. And then in cause number 21-36615, also find counts 1 through 5 true, find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance. Sentence you to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. All of these sentences will run concurrently, which means together at the same time. I'm going to hand you the trial court certification that shows there was no agreement. You do have some rights to appeal. You need to sign that with your attorney, and then I'll give you that copy. Also, I'm handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler.
Right here. And what is it stating in our way?
It's saying that you do have a right to appeal, and Mr. Kimler will talk to you about that.
When do you find on the phone?
You hand her that one and just the bottom copy off of that one, Mr. Kimler.
When can I find this great time?
They'll do the judgments today, and it should show up in the computer probably in the next day or two.
It's the jail that's not giving us this information.
It's, well, right now it hasn't been all calculated, so it'll be in the system in the next day or two. Once the clerk, she's in court right now, so she can't do it, but it'll happen the next day or two. Mr. Burbank, you've got Leroy Harris.
Halfway through TCF Live on this last day of June, episode 322, I believe, today. Good to have all of you here with me today. We're going to continue to ride with Judge West for a little while. There's a few different courts that I'm monitoring, but she's the best show in town at the moment, so we'll stick here for a little while.
Good morning. Are you Leroy Harris Jr.? And this is cause number 24 DCCR 0404. Mr. Harris is charged with a first-degree felony offense of murder from December 3rd of 2023. And Mr. Harris, that indictment alleges that you were previously convicted of robbery May 9th of 2012. And also in 2 cases on that same day. And what that means, sir, is that if you go to trial in that robbery case and the murder case, and the robbery case is true, that conviction, then you would be considered enhanced punishment, which means your punishment would be, if you're found guilty, a minimum of 15 years, up to 99 years or life in prison. Do you understand? And I have a plea bargain rejection here on the tablet, and I'm making that notation that I've admonished them to the enhanced. It shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 40-year term in the murder case with a dismiss in the pending felony. What pending felony is there? Well, that's the MTRP. So really wouldn't be a dismissal of it. It's just the MTRP on a state jail felony. Well, so I'm going to mark through that also. Whatever happened, if you took that 40 years on the murder, then something would be figured out with the state jail felony motion to revoke that would run concurrently or at the same time. Correct?
Yes. And Judge, I apologize. I think Mr. Burbank and we were trying to talk over a bunch of people. That should be 30.
30,
Yes.
not 40.
Correct.
So is okay. So Mr. Harris,
I don't think it makes a difference, but just the paperwork.
So the offer is for 30 years in the institutional division of the Texas Department of Corrections. Do you understand what your options are if you wanted to enter a plea of guilty? And do you want to reject that offer and have your case set for trial? All right, we'll get it set on the trial docket, and Mr. Burbank will begin preparation for trial.
Thank you. I
Thank you. Yes.
And Judge, just may I, for the record?
Yeah, hold on just a second.
Why this case is the age it is obviously the court is aware. Mr. Harris, having been in Harris County, there has subsequently been a conviction over there for murder. I believe it was a lesser included of a capital. He received 12 years on that. It will be my intention to get from Ms. Rogers, the DA over there, what I can, probably a PSI, and get that to Mr. Burbank, but it just adds a little bit of supplemental discovery just at this juncture. So we'll keep the court informed if that changes our negotiation. I'm just not quite at this point in a position to make any other offer. If I am, I'll come to the court first.
Okay, thank you. All right, you can go back with the bailiff. And then you've got Asa Jones, Mr. Burbank.
I think we previously had.
Yeah, this is pretrial for Monday. Morning, Mr. Coleman. Mr. Coleman, I've heard some.
I know, James. It's unfortunate. I'm a team player.
Some very unfortunate news.
Team player. I go where the coach.
I don't like that team. I like the team I've got right now.
I go where the coach tells me as a member of the team.
Team is being downsized.
The team is being downsized. Right, sir, you're Asa Jones, and this is cause number 25 DCCR 0963. Mr. Jones is charged with a first-degree felony offense of aggravated assault, and the case is set for trial to begin with jury selection next Monday. And what is the announcement?
You should be ready to.
Station ready.
All right, it is likely going to be at the top of the list. I have one other that's potential, but it sounds like there might be some issues. So, but you'll know today after docket. I do want to make sure you understand, Mr. Jones, that after today, I will not accept any plea agreements. It looks like I've got a plea bargain rejection from January of this year where you rejected a 25-year term. Has there been any change in negotiations?
No, Judge. Your Honor, we have a witness that we asked the court, call the name of, please.
Okay,
Atlanta Gallo.
Atlanta Gallo, please.
We asked that the court admonish her, she's under subpoena, admonish her about the consequences of not showing up for the trial next week.
If you'll just have her come over here on this side. Good morning, ma'am. And your name's Atlanta Gallo?
Yes, ma'am.
And Ms. Gallo, we're here in clause number 25, DCCR 0963, and Mr. Jones' case is set for trial for next week to begin on Monday. You are placed under subpoena for that, and I just want to make sure you understand that it is required by law that you show up, whether you want to or not, for court next week. At whatever time the district attorney tells you and whatever time that subpoena told you, you have to be here. If you don't come, now that you've been given this order and that subpoena, there could be some consequences where you would get in trouble. Do you understand?
Yes, ma'am.
You could be held in contempt of court. There would be a fine. You could potentially go to jail yourself for not showing up. Do you understand? Okay. All right. You're free to step back out.
Thank you.
All right, anything else then? So, Mr. Jones, I do want to make sure you understand that after today, I will not accept any plea agreements. And again, it's very likely that your case will be at the top of the list. Mr. Burbank will know that after docket today. Do you understand?
Yes, ma'am.
Okay, I'll let you know after docket then.
I have excuse, Your Honor.
Yes, sir.
Good about that. I talked to him and
Ms. Perazzo, you've got Logan Eaglin.
Logan
Mr. Smith.
Logan.
Good morning.
Sorry, I got his stuff yesterday.
Good morning. Are you Logan Eaglin?
Yes, ma'am.
And this is cause number 26 DCCR 121123. Mr. Eaglin is charged with murders. Case is set for trial to begin with jury selection next Monday. What is the announcement?
Your Honor, so there is some additional discovery that was just provided to me, and I have not had a chance to review that with my client. So I would like just one more brief reset so I can visit with him and go over all of that discovery.
So I guess my question is, if it's just going over discovery with him and making him aware of all of that, then I feel like that's something that could take place soon, today, go over everything. If there's any change, y'all could let me know, unless there's some other investigation or information that you're still waiting on or you need to find out.
No.
Okay, well, do you want to?
There is, I mean, it was, an additional witnesses come forward, that, this defendant has made a admission to, about committing the crime. But it is another inmate, so we would, I don't know, I think if they want time to investigate that, maybe even having try to interview him. State would not be opposed to that. We're not opposed to resetting it one time for trial.
Is that your intention?
Yes, Your Honor.
Okay, so I'm going to, and it was also, it looks like it's been reindicted. This is the third reindicted?
Yes, Judge.
So, which, I mean, the information that you have is all the same other than the new information that you just got yesterday, is that
Yes,
correct?
and then I also got some new media yesterday in this case.
So here's what I'm going to do. I'm going to reset the case 45 days on an announcement docket. That way, if there's any change in, well, actually, I'm just going to reset it on announcement 30 days. If you need an investigator, you can get that, make that request
Yes,
quickly.
ma'am.
We'll get you the funding for it. That way, if they need to go visit with any additional witness, let's try to get it all done within 30 days. If something changes and there's some deal that we reach on the 30th day, great, then we'll take care of it. If not, it'll go right back on the trial docket at that point instead of us waiting 3 months for another trial docket.
Yes, ma'am.
Okay, all right, you can go back
Thank
with the
you.
bailiff. And then you got Thaddeus McCray.
Yes, ma'am.
Can you make a note on either when I look up the new clause number, none of the old that has been brought into that new clause number. So I don't put any of the objections or anything in their way for all, I need everything to be transferred to the new case. And it's probably from those two prior, not just one, but two prior indictments.
Roughly.
All right, sir, you're Thaddeus McCray. And Mr. McCray is charged in cause number 26 DCCR 0399 with the first degree felony offensive murder. And in cause number 21 38959, we've got a motion to revoke probation for an aggravated assault causing serious bodily injury. And what is the announcement?
Your Honor, essentially it's the same announcement that I just made previously on the last case. There were some items that were missing from discovery that I requested. They were just recently responded to and provided. I'm not sure if everything that I asked for was provided, but I need to review all of that and go over that information and evidence with my client just
Okay.
to ensure that we have everything.
Sure. So we'll do one more reset. Is there anything else that you know of that you're waiting on that she does not
No,
have?
Judge, these were things that she had asked for that weren't in the file that we went and got.
Good,
and brought
okay.
into the file.
So, Mr. McCray, I'm just going to reset your case, a normal reset for about 30 days. That'll give Ms. Peraza some time to come go over all of the new information that she's received. At that next full day, we'll need an announcement whether or not you're going to go to trial or if there's some deal that's reached, okay?
All right.
All right, thank you. Mr. Rojas, you got Jaden Brantley.
Brantley, Jaden Brantley.
Okay, so she's gonna, they did work it out. So Mr. Kimler, Ms. Holmes is gonna take care of
Yes,
that
ma'am.
for you. Okay.
I've
perfect.
told them that.
Okay.
I have told the advisor.
Thank you.
Okay, friends, let me interrupt Judge West for just a moment. We are a court channel. We do cover law stuff. This is breaking news from the Supreme Court. They have upheld birthright citizenship, rejecting Trump's proposed limits. This from the AP. Supreme Court on Tuesday upheld a broad conception of birthright citizenship, rejecting President Trump's executive order declaring that children born to people who are in the U.S. illegally or temporarily are not American citizens. The justices relied on a long settled understanding of the 14th Amendment adopted after the Civil War and more recent federal laws in ruling that anyone born in the country, with very limited exceptions, is a citizen. So, breaking news there. Let me know what you think in the comments. I will form my own opinion on that as I consider it. But yeah, that's big news. Okie dokie, with that having been said, let's get back to Judge West. She continues to be the best show in town at the moment.
First degree felony offense of aggravated robbery from February 6th of 2026. What that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 5 years and up to 99 years or life in prison. Do you understand? And I have here on the tablet a plea bargain rejection that has your signature on it with Mr. Rojas's that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a cap of 25 years in prison, which means you would be leaving your punishment up to me. And if I follow the agreement, I cannot give you more than 25. I could give you 25, I could give you less. It would all depend on the information that was brought to me at a sentencing hearing. You have every right to reject that offer, have a jury decide if you're guilty or not and what your punishment is. I just want to make sure you understand what the possible consequences are if you go to a jury trial, what your options are if you wanted to plead guilty. And do you understand all of that? And do you want to reject that offer and have your case set for trial?
You want to set up a trial?
Do you want to visit with Mr. Rojas again?
You talk some more?
Okay, I'll hold it. And if you need some time to go out and visit, just let me know. I can give you a week or two, but I'll hold it for a little bit.
Yes, ma'am.
All right, go back with the bailiff. And I'm just gonna, I'll have that on here.
Okay.
If you still want it, it'll be here. Oh, you got Manuel Cardenas. It's a sentencing, Mr. Rojas. Good morning. Are you Manuel Cardenas Junior? And Mr. Cardenas was previously in court, entered a plea of guilty and cause number 26 DCCR 0040 to the third-degree felony offense of injury to a child, elderly, or disabled individual. And that was for an agreement of 5 years deferred probation. I received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor.
I have, Judge.
Any additions or corrections?
Not from the defense.
Judge, my only position would be that obviously as indicated by the PSI, this incident does not stem from his criminal history, so to speak, but more likely probably a mental health or a narcotics induced incident. It's obviously concerning with regard to his father. We'd ask that a no contact order remain in place, but defer to what you think is appropriate.
Okay, so Mr. Cardenas, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. That includes, among other things, but that does include that you will enter and successfully complete the safety program. So that can help you with any drug or alcohol related issues. When you get out, you will also be placed on the mental health initiative caseload to help with any other issues that you may be having, so that you will have all the tools to be able to be sober, healthy, and obviously not have anything like this happen again.
Yes, ma'am.
You will also be required at this time to have no contact or communication with Manuel Cardenas Senior, your father. That's until further order of the court. And so if there becomes a time on probation where you feel like you're in a good place and he wants you to be around or something like that, you have to go through probation. You have to get my permission to do that. He can't give you permission.
Okay.
So he can't say it's fine, come over, it's Christmas. If you do that without my permission, it's a violation of your probation. Okay. If you do everything you're supposed to on this probation, you're about to get all the tools you need to be successful. You don't have a felony conviction. You should be able to finish it. And at the end of your probation, if you're successful, the case is actually dismissed. You'll never have a felony conviction on your record.
Sounds good.
The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and I could send you to prison for anywhere in the punishment range, which is between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. Good luck to you, sir.
Okay.
Mr. Vasquez, you have Corey Como.
Me?
Oh, I just saw him. Did he go somewhere? Well, don't call. I don't know where Joel is, so I'll skip that. Let's see. Mr. Rojas, you got Jimmy Couch.
Couch.
You're here for Bruce? Yes, ma'am. Okay, I'll take care of that just a second.
Okay.
Yeah, I know that. There you go. How you felt? You know, you do not see it.
Computer stuff.
Good morning, Judge.
Good morning. Are you Jimmy Couch?
Yes, ma'am.
Y'all give me just a second. I just don't know.
We're gonna like a statue. We can know that it's attempted.
Yes, well. That's coming. Mr. Couch.
Yes, ma'am.
Pay attention this way. All right. Will he waive the formal reading of the indictment?
He will, Your Honor.
Mr. Couch, in clause number 26, DCCR 0328, the state has elected to proceed on the lesser included offense of a third-degree felony attempted burglary of a habitation. And that's from January 29th of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Now, it looks like the agreement that you've reached is for a 3-year deferred probation. There will be a $500 fine. You'll be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Oh, yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Couch is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, but I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back at a later date for sentencing. Ms. Malfino?
Judge, the state would respectfully object to any type of PSI bond in this case because of the fact that we're going to very strongly urge the court to consider safety. I have met multiple times with the complainant, Ms. Couch, in this case. She is actually present in court today. I think there is an underlying severe substance abuse issue that has contributed to all of these issues. And that will be the position of the state to ask for safety. And I'm afraid that if he's out in the interim, it will derail that and also this absence of contact with her at this point.
So
I understand that's the state's position.
Sure.
Judge. Mr. Couch is requesting that you do consider allowing him to be released. He's been in jail now for
4 months.
4 months. He's getting some taking AA classes in jail.
Rocco.
He's got some health issues that he desperately wants to get on the outside and
Yes, ma'am.
addressed.
I have a spot on my lung. I was supposed to be in Baptist Hospital for another PET scan and another biopsy. And it's just getting worse by the day.
Well, if Mr. Rojas, if you want to get some information to the court between now and sentencing, I can bump something up with regard to a bond hearing. But today, based on the allegations and the concern, what I'm going to do is not change the bond. I am going to ask probation to do go ahead and get a substance abuse assessment during that so that we have everything in place when we come back for sentencing. All right, you can go back with the bailiff.
Okay, thank you.
Alrighty, friends, about to enter hour 3 already of TCF Live. Let's change it up a little bit because we've been here for a while. Let's go back up to Pontiac, Michigan, and Judge Bowie. He's got a new contestant appearing in person this time.
251-555 SM People State of Michigan versus Carly Down Sparks. Appearance of record.
Good afternoon, or good morning, Your Honor. Work Vice on behalf of the people.
Thank you. Good morning, Your Honor. Nick Bagus on behalf of the Sparks. Please repeat my right.
Carly Sparks.
Okay, we're here for sentencing. You had an opportunity to go to the pre-sentence report. For Ms. Sparks, Mr. Back, is there any corrections, deletions, alteration need to be made to the report?
Thank you, Judge. I have to review the report with my client. I think the facts will be correct ahead of the meeting.
All right, please come out, get an opportunity to go report.
Right. Your operations.
All right. Mr. Backus on Ms. Sparks behalf.
Thank you very much, Your Honor. First note, this was a no contest plea and reason for the potential collateral civil liability as such. I have advised my client not to make any statement with respect to elocution. What I can tell the court is that I've observed firsthand the worse that she has with respect to what occurred as brought her in the court and is being sentenced for today. There was some additional context, which we did discuss with the court, talking about potential cause. That context does remain an appropriate mitigation, but I don't see the need to hardline this morning, Your Honor, because at the end of the day, there was no justification for the decision that Ms. Sparks made in the that she exhibited. And I think he absolutely acknowledges that you guys did not deserve the ruling that she went through. With that being said, Your Honor, Ms. Sparks does appear before you having absolutely no prior criminal contacts whatsoever. I do firmly believe that this will be the first best and one. She comes from a law enforcement family. Her father's a police officer. In the wake of the incident, she did take various steps to address some of the decision making here. She voluntarily began seeking therapy to better her online interface. She's continuing to do that. She's faced just tremendous ramifications as a result of what occurred. She lost her job. She lost her, various, other, insurances and other benefits of that job. It's appropriately, but it hasn't been just a major reality for her. We know the jobs in this case, Your Honor, to a 6-month term of non-reporting probation, and the anger management programming looks like probation does agree with it. Simply has an inquiry to contact directly the agency. Thank you. Okay.
This coming on, she had an opportunity to report.
I did, Your Honor. I would like to note the complainant, the victim in this matter, is present in the courtroom. She did advise me that she wants me to read the letter that she wrote to the court, if I may do so.
Okay. You may proceed.
My name is Jessica Rutka. Your Honor, I understand a plea has been taken here today, which leaves me without the chance of going to trial and getting answers of why I was physically assaulted just over 6 months ago. I would ask that you, Judge, take into consideration the video evidence of the unprovoked attack in December, where I was blindsided, repeatedly hit in the head, and given a concussion outward. I asked that the defendant pay the hospital bill from the care I received after the assault, also for her to remain from my place of employment. Thank you for your time. Judge, she also did provide me with the medical bill and showing defense. It's in the amount of $161.43. I would ask that the court include that as part of her sentencing institution.
Thank you, Your Honor. I'm doing this different. Receiving it. I haven't looked at my file.
Okay.
Can we step outside just very briefly?
You may. We'll go off the record.
Well, we are a few minutes in the Wayback Machine on this, so let's see if we can bump past this little pause here. There we go.
Victim complete anger management through step 4 and pay $75 crime victim fee and $90 PSI fee. So I'll adopt that recommendation. Give me 1 second.
Thank you, Your Honor.
Those are sworn. What are those sworn?
Yeah.
Yes. All right, so it'll be a 6-month non-reporting probation, and you're not to violate any criminal law in the government unit. You can leave the state, but just let us know when you're leaving the state. And we find out to say, hey, I'm popping out of the state. I'll be back in a week, 2 weeks. You need to know where you're at. You're on non-reporting probation, so you're not required to monthly, report. But however, you're still in the jurisdiction of this court and our probation department. So they call you randomly, just pick up the phone. They want to get an update of what you're doing, how things going. Answer truthfully. If they ask you to come in, just come in. If they do it over the phone, just do it over the phone. The update. If your address changed, phone number, if you're going back to work, going to school, let us know immediately. It is the probationer's duty to update the court of contact information, such as that type of information. Not to possess any firearms, ammunition, or other dangerous weapons. Don't be around people with those items or areas where those items are present. You will complete anger management through step forward. And then not to have any type of contact directly or indirectly with Jessica Bukvik. Fines, fees, and costs are as follows. $75 for the crime victim, mandatory fee, 106.43 for restitution, a mandatory $50 minimum state cost. It's a fine of $500 on the charge, $150 for the court costs. You have a flat supervision fee of $100, and then the $90 PSI fee. So this is going to be $1,126.43. Now, we can break that up to a 6-month payment plan. So that would be $187.74. But on our last month, we're going to have a big payment, a double payment, okay? I give you that amount. So it's $187.74 per month. We'll begin that next month. So you make beginning in July 2026. Then the last month of probation, that final payment multiplied by 2 will be $375.48. All right. So you're all set. If you have any questions ever about your probation, just call the probation department. Or if you're not getting anything on the phone or email, just come in, okay?
Hey, did you want us to check out probation data, step forward information, or how did you go into?
Yeah, go downstairs and speak on how you can get step forward.
Okay.
Yeah, they'll give you a number and you can call and get that set up.
Good day, everyone. Thank you very much.
We're all set. Thank you.
Now, I'm not saying, but I'm just saying, something just occurred to me. We hear this a lot from a lot of different judges around the country. He just said to that defendant, if you ever have any questions on probation, give them a call. If you're not getting a response, come in and see us. We hear that all the time. The system is that broken. Think about it. That the judges have to go, hey, you know, odds are 50-50. You may not get a response from the people who are supervising you. So, you know, come on in. That's messed up if you actually just sit and think about that for a minute. Anywho, let's do this. Let's go back to Judge McNally. Check back in with him.
A and B. Sign an advice of rights form. Yes, you did. Okay, your name?
Arnold Morte.
So this gentleman, you met with the prosecutor, right?
Yes.
I arraigned you. You met with the prosecutor. She's offering you the opportunity to plead guilty to allowing an unlicensed driver to drive and speeding 1 to 5 over, with the understanding that the no ops charge will be dismissed and the careless driving charge will be dismissed. Is that your understanding? Is that how you wish to proceed?
Yeah.
If you plead to 1 to 5 over, that's 1 point. But you're getting the 3-point violation dismissed. If you plead to allowing an unlicensed driver to drive, that's 0 points and it won't go on your record. And that is a 0-pointer punishable by up to 500 fines, 90 days jail, costs, or all those. Do you understand that?
Yes.
Did you sign, read, and understand an advice of rights form here today? If you plead guilty, you'll be giving up all those rights and we're not going to have a trial. Do you understand that?
Yes, Your Honor.
All right. You have the right to a lawyer. I told you that before. I'll tell you again. Do you want a lawyer?
No.
To the charge allowing an unlicensed driver to drive, how do you plead?
Yes.
To the charge 1 to 5 over, responsible or not responsible?
Yes.
I can't hear you.
Yes, Your Honor.
You plead responsible or not responsible? Were you in control of a 2008 Chevrolet silver in color that was being operated on June 9 to 26 at 6:53 p.m. On the ramp 226A near Sibley Road in Brownstown?
Yes, Your Honor.
Did you allow somebody to drive that was unlicensed or suspended or revoked, and was that you?
Yes.
And are you on probation or parole?
Yes.
Were you on probation or parole on June the 9 to 26? Probation or parole? To what court? On a felony?
Yes.
You understand by pleading guilty, I'm just telling you, this could be deemed a violation of that probation. That probation could be revoked. You could be incarcerated on that charge as a result of this misdemeanor plea and conviction. Do you understand that?
Yes.
You still wish to plead guilty? Anybody in the world force you to plead guilty?
No.
Plea is accepted to allow an unlicensed driver to drive. I'm dismissing the no ops, accepting the plea to 1 to 5 over, dismissing the careless. I'm ready to sentence you. Are you ready? Anything you would like to tell me before I sentence you? You don't have a valid license. Wait till you get your license, it's suspended.
I've been going through a payment arrangement.
I'm sorry?
Payment. I've been going through it for payment arrangements.
What courts?
36th district.
Anything else? 100 fines, 75 costs, 75 victims' rights, $50 justice assessment, 300 or 60 days. Do you have all that with you today?
Pardon, would you say that again?
$300 or 60 days, and I'm going to charge you $150 on the speeding. So you need $450. Do you have all that with you today?
Not right now. I feel like in 60 days.
Where do you work?
G and F. I mean F and G. F and G's.
Can you pay anything today?
I just really started really last week, and it's a 2-week period, so the 60 days will be fine. It'll be actually purchased up to $450. I just started really last week.
I'm gonna have you pay the $150 on the speeding by July the 24th. Can you do that?
Yes.
I'm gonna have you pay the $300 on the other case by August 21st. Can you do that?
Yeah.
If you don't have the money, there's no reason to be scared. Just call the court. We can go on Zoom, or you can walk in, Your Honor, before the due date at 8:30, and I'll be glad to give you an extension. Fair enough?
Yes.
Good luck. Thank you.
Okay.
Yeah.
Let me see what it's is written and find out.
Sure. Sadie. Do you have the police report on that one yet, on Kennedy, Lisa?
Yes, I'm printing it right now.
Okay. Hussein, I'm sorry, Mashu Hussein, 26B 711-738.
Good morning, Judge and staff. John Graziani on behalf of Rashad Hussein, Mashoud Hussein, who's to my left. Please identify yourself, sir.
Mashoud Hussein.
Judge, I spoke with the prosecutor, and we've agreed to adjourn for the police, but there's a separate issue. Apparently, Mr. Hussein would like to represent himself. I have no problem with it. He's not hurting my feelings. And if he feels he could be better, I no problem.
What law school did you go to?
What's going on with college?
Yeah, I know, but what law school did you go to?
I think we're in law school, Your Honor.
You think you can do better than him?
It's not that I can do better than him. It's just that the case has been going on for so long.
It hasn't been going on that long. Listen, we started the case, you were arraigned on May 22nd. It's been going on for 5 weeks. Well, listen to me, sir. I want you to listen to me. You can represent yourself if you want. I don't know why you'd think you could do better if you went to Macomb County Community College. No disrespect intended whatsoever. It's more than some people do. This guy's been practicing law for 30 years, right? 35?
I can't believe it. 35, 36 years.
He's a good lawyer.
Thank you, Judge.
This is a serious case. You got a domestic violence charge. I'm just telling you, I'd urge you to reconsider. You have the right to represent yourself. You do. Everybody does. You could be charged with murder and you could still be allowed to represent yourself. It's just, I'm telling you, as a guy who's been around the block here, you're hurting yourself by representing yourself. You don't know anything about the rules of evidence, do you? You know what the rules of evidence are? I could take 10 days to explain those to you. There's all kinds of legal objections that you don't know anything about, sir. There's manners in which you can and can't ask questions. I'm just encouraging you not to get rid of your lawyer. I'll be glad to give you 2 weeks, but because the case is still pending, 5 weeks later means nothing to me.
It's just that, like, this was supposed to be my final pre-trial, but then it was supposed to be a pre-trial. I was going to be last time I was in Florida. It was supposed to be a final pre-trial, and it just, this time has been going on. And I don't have a place to live right now. I'm living off a hotel, I pay $500 a week.
Where at?
Days in the morning. I'm from Sterling Heights, and I don't live on this area. I had a home, and I lost my home while facing through these battles and tough times right now. In the process of going to court of my home that I'm living in. I'm about to be evicted, and I don't even live at that home. So in this case, that where the other victim's not here, it's not showing up. That's why I'm like, literally.
Who's the victim in this case, Mr. Graziani?
It's an ex-girlfriend.
Is she living in the house?
She was.
She was living in the house. I suggested him that he could move in, with permission from the court. However, it appears that everything's been shut off and it's basically a little, without any water, Judge. It's pretty bad from what I understand. But for the record, what Mr. Hussein.
Hang on one second. Can you staple this and mark this P? You're not helping by getting rid of your lawyer and representing yourself. Let me be blunt about it.
Understand.
So why don't I do this?
It's just that I put the judge speak. I'm trying to figure out what my final pre-trial is, and I'm trying to understand that the victim isn't coming here.
Well, I can make him come.
Yeah, I understand that, but it's just that.
Call him Ms. Holloway again, John.
Good. I'm trying to understand that, like, this issue is, I'm trying to have it resolved. I'm trying to get back on my feet, go to work. I can't go to work. I don't have my car. I don't have a home. I don't have a place to live.
Have you guys conversed with the victim on this case involving Mr. Hussein?
Yes, Your Honor. As of yesterday, I believe I spoke to the defense. She is still following.
That means she wants to proceed.
He wants to get rid of his lawyer. This makes no sense to me. Here's what I'm going to encourage you to do. I want the victim here at the next pretrial, okay? I'm ordering her to appear. I'm setting this for July the 14th. At what time, Lisa? 9:30 or something?
Yes, 9:30.
Just to clarify, are you ordering people to send out a subpoena?
Yeah, I don't care however you do it, whether you call her, tell her the judge wants her here on July the 14th at 9:30. But if she doesn't show up, I'm going to entertain a motion to dismiss. Now, I'm going to encourage you to keep your lawyer for the time being. You're not helping yourself by getting rid of your lawyer, okay? You're making it worse. Do you understand that? Now, if you want, since you seem to be in a hurry, if you want, I can set it for trial today too, for another day. I'll be glad to do that for you.
Is that the final pre-trial?
Well, I'm going to have a final pretrial in 2 weeks, at which time the victim has to appear. And if she doesn't appear, I'm going to dismiss the case on motion of your lawyer. You can also set a trial, whether a jury or a bench trial, 4 weeks down the road or 3 weeks down the road. So If you guys want to entertain that, either a jury demand or a bench trial, but he wants to get rid of you, so maybe you don't want to make that decision.
Judge, I feel uncomfortable at this time.
Are you willing to keep your lawyer through the next pretrial?
Is that in 2 weeks, July 14th?
Yes. I'm not gonna be here next week, so I can't do it next week.
Yeah, that's fine.
If you want, I'll get rid of your lawyer. You're making a big mistake.
Yeah, I love, that's fine. I look like that.
You want him to?
Yeah.
July 14th, 9:30. We'll see everybody here then. Thank you. Charles Bejuan Boyd. Two 6W 706-997.
Good morning, Judge and staff. John Graziani, here on behalf of Charles Boyd. Judge, we had the opportunity to review the pre-sentence.
Your name, sir?
Charles Boyd.
Okay, so I'm sorry. Go ahead.
Judge, we had the opportunity to review pre-sentence report. There's no additions, deletions, or corrections. We are asking, however, that the no contact order be lifted. We have evidence that shows that his daughter contacted my client and,
Where's she at?
currently,
Well, no, I'm asking, is she here, Lisa, Tahari Boyd?
Oh, not on Zoom.
Judge, she's not here. We do have evidence of text messages from her, which indicate that she wants to move back with Mr. Boyd, and
Well, I gotta have her here to tell me that. I can adjourn the sentencing a week or two and 2 weeks and have her.
Judge, if we.
I can have probation call her. I mean, I'm not gonna look at text messages that she sent him without her being here and lifting a no contact provision, whether it's part of a bond or part of a sentence.
Judge, if I may, if we could possibly adjourn this matter simply for an hour. It was adjourned before. It was our understanding that parties would show up. Unfortunately, she hasn't shown up. I think transportation is an issue.
She can Zoom, but she can't. Let me do this. I constantly am looking for the prosecutor and I can't remember what number she's into. Do you have any idea what number Ms. Holloway's in, counsel? I mean, Lisa. I believe I need to get a hold of Ms. Holloway. I'm going to have her call the victim and tell her I want her to Zoom in.
Thank you, Judge. Thank you so much.
She's in a breakout room. I'll try to move her out.
Okay.
I'm sorry for the interruption. May I have a breakout room too, please?
Miss Louie?
Esmaro.
Or Miss Esmaro. Yeah, sorry. Hold on.
It's okay.
Yeah, I can't get her to move, Judge. I'm sorry.
Do you know what conference?
Oh, there she
room?
is. There she is.
Ms. Holloway, can you state your name on this, please? This is on Charles Boyd.
Hi, good morning.
Your name, please?
Nora Alloway on behalf of the people, PA 6528.
This is a sentencing on Charles Boyd. He pled to attempt DV. This involved his daughter, Tahari Boyd. I'm hoping that's the defense lawyer is asking me to lift the no contact provision. He wants me to look at text messages. I'm not going to do that, but I think in fairness, they want me to lift it saying she requested it and messages sent to the defendant. And I have a no contact. I'm going to ask that you or the victim's advocate call Ms. Boyd and ask her to Zoom in here at about half an hour or so. And then I can address it. Fair enough?
We can do that. Your Honor, just to clarify, this one isn't my case, but I will tell the victim advocate right now to speak to her and Natalia Asmaro can.
These days, I'm
be on
going to
the
figure
record.
out who gets what here, you know?
That's okay. We'll handle it. Thank you.
Thank you very much. Thank you. You can have a seat, sir.
Thank you, Judge.
All right. Now, do you have that marked? All right. Recalling James Allen Kennedy. 26G 703768. They came in with a big packet. I've had the whole thing marked. Counsel, your appearance.
Jason Kazmarek on behalf of James Kennedy. James Kennedy.
I'll be happy to take your no contest plea to operating while intoxicated first, with the understanding that the super drunk will be dismissed, and further with the understanding that there was an accident and apparently there's an allegation that some were injured as a result of the defendant's intoxication. So I'll go ahead and take that. Do you stipulate I can use the police report to establish a factual basis?
Yes, Your Honor.
Sir, a no contest plea has the same effect as a guilty plea. Do you understand that?
Yes.
You plead no contest to the charge of operating while intoxicated. The possible penalties are up to $500 fines, 93 days jail, 360 hours community service. Court costs are all of those 6 points, license suspension or revocation in accordance with your record. And your vehicle could be or might have to be immobilized depending upon your record. Do you understand that?
I do.
You are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to a trial by court or a trial by jury. You have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses, and to testify or remain silent. If you remain silent, that silence would not be held against you. If you plead guilty, you're giving up all your rights, including your right to a jury trial. And you're waiving the presumption of innocence and waiving the requirement that they prove you guilty beyond a reasonable doubt. Do you understand that?
I do, Your Honor.
All right. Now, a no contest plea, as I said, has the same effect as a guilty plea. You understand that?
I do.
I'm going to ask you how you wish to plead to the charge of operating while intoxicated, first offense.
Plead no contest.
All right, counsel, I've had the report marked. You said you stipulate to the admission of it for purposes of the plea, and I'm going to go ahead and take a look at it real quick.
Sure.
All right, based upon my review, I see. Based upon my review of the report, and there's a big stack here, I find there's a factual basis for the plea. Sir, are you on probation or parole?
No.
Anybody force you to plead no contest?
No.
Plea is accepted to no contest to that charge. I find the plea has been made voluntarily and understandingly, and is an accurate plea. He's soon to be 25, correct, counsel?
Yes.
Has he had any criminal contacts other than this one? I had an MIP in 19.
Juvenile, I think, yeah, I don't remember anything else.
Couple, leaving the scene of a property damage. I want you to go into alcohol. Here's what I'm going to do. I'm going to say a personal bond, $1,000. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. No alcohol, no illegal drugs, no marijuana. You're not to purchase, possess, or consume any one of those. And you are to attend AANA at least twice a week. You have to go in person. You have to go in person. And every time you go, you have to have the form signed. No contact with prosecution witnesses. When I say that, we can give you a form. You seek out my court officer. You're coming here for a screening and assessment. We're going to hand you an AA verification form. Every time you go, you have to have somebody there verify your attendance by signing it for you. AA twice a week in person, and you have to go to the Gibraltar Police Department, be fingerprinted and photographed today by 2 p.m. Do you understand that, sir?
Yes.
We're going to send over an order to them. So you'll come back here, you'll fill out a questionnaire, you'll be interviewed, and then you'll go over to the Gibraltar Police Department to be photographed and fingerprinted. And we'll set a sentencing date, AA twice a week, no contact with prosecution witnesses. Also, no alcohol, marijuana, or illegal drugs. You cannot leave the state, cannot violate a law. You must appear in court as directed. What do you have for me as a sentencing, Lisa?
July 14th at 8:30.
Good with you, Mr. Kazmarek?
I'm sorry, July 14th at what time?
8:30?
Can we do the following week?
Yeah,
If possible?
21st
That'd be great.
at 8:30. Okay? Any
Thank you, sir.
questions, Mr. Kazmarek or Mr. Kennedy?
No, Judge.
Thank you very much. Good luck, sir. Come on over to the courthouse. Thank you.
Thank you.
People against Sanchez Gomez and Bidundo Andres Sanchez Gomez, 26M 690-991. What is this? Informal. Okay, where's Mr. Sanchez Gomez? Is he here? What's your name, sir? You have to unmute. Now you muted again. Tell me your name. Unmute. There you go. Tell me your name.
Oh, me? Sorry.
Yeah.
I wasn't sure. Edmundo Andres Sanchez.
All right. Well, you're a winner today. The officer didn't show up. Case dismissed. It was scheduled for 10. It is now 10:36. You're all set. Just be, let me see here. Just slow down a little bit, okay? Good luck
I will
to
for
you.
sure. Thank you so much.
Thank you. Butler.
Bye-bye.
People against Butler. Damian Deshaun Butler, 216-706-769.
Good morning, Your Honor. Your great staff, Attorney Quentin Dox, plea number 79657. On behalf of my client, Mr. Butler. Mr. Butler, state your full name for the record.
Damian Deshaun Butler.
I didn't even see this report, but apparently it came in. And all right. So, counsel, you stipulate we're going to have a competency hearing, and it says that you and the prosecutor stipulate to the competency report. Unless you see a reason to, I'm going to just go ahead and have this marked. You stipulate I can use the police report to establish establish a competency here.
That's right. Yes.
Not the police report. Forgive me. Jeez.
I know
I'm sorry. You stipulate to the admission of the competency report.
Yes, Your Honor. Yes, Your Honor.
All right, I've had that marked Peoples 1. So I've reviewed the report, and just give me 1 second here. Thank you. Court has reviewed the report and the findings of Margot Gilbert, licensed psychologist. The court finds the defendant competent to stand trial. Make sure that stays as a non-public record here. And then when are we going to do the exam? Can we do it on the 14th?
Yes, Your Honor. I believe if we could do 1 o'clock, that's fine.
You have an afternoon flat rock that day, Judge?
Can you not do it in the morning?
Your Honor, I'm jammed in the morning. I'm jammed in the morning in Third Circuit Court.
What about the 21st?
I can do it then, Your Honor. That's fine.
We'll do it the 21st at 10:45, okay? 21st at 10:45. And we'll have the defendant read out. All right. Thank you very much. I'll see you guys here then. Thanks.
Alrighty, friends. Final half hour of TCF Live. Day has flown by, as they normally do. Let's go back to Judge West, who previously was pretty much just holding murder court. Let's see if that's still going on or if she's got different contestants.
Good morning. Are you Bragan Fuelsman? And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Hulsman, in cause number 26 DCCR 0199, the state has elected to proceed on the lesser included offense of a Class A misdemeanor assault, and that's from January 7th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, sure.
Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for, hold on, it's back. A 2-year deferred probation. There would be a $250 fine, and you would be required to follow all of the rules and conditions of probation. Part of that would be that you would follow any recommendations with regard to any mental health care issues. Do you understand? State tenders number 1.
No objection.
It's admitted. And are you a U.S. citizen? All right. Is there any evidence that Ms. Hulsman is not competent?
None that has not already been addressed, Judge.
Okay. All right, then, Ms. Hulsman, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of the plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 2 years. You're ordered to pay the $250 fine, and you're ordered to follow all of the rules and conditions of probation, including any mental health care. If you do all of that, this is a great opportunity because you won't have a conviction on your record. And at the end of the probation period, if you successfully complete it, the case is dismissed. The other side of that is if you violate any condition of probation, you can be brought back into court and you could be convicted and sent to our Jefferson County Jail for up to 1 year. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You'll get some instructions from probation today so that you'll know exactly what to do when you're released from jail. Make sure you do all that, okay? All right, you can go back. John McMillan. Mr. Rojas. And Ms. Muffin.
Hold on that for 1 second.
Sure.
Well, call, I sent a letter, I need to go grab some people from that.
Okay, I'll hold it. Ms. Shipley, you're here on Brandon Lewing for Mr. Smith.
Yes, Your Honor. Brandon.
Morning.
Good morning. But I thought everything.
And they take you down the right now. It's still going to be harder for them.
Good morning, sir. You're Brandon Lewing. And Mr. Lewing is charged in cause number 25 DCCR 1402 with the state jail felony offense of unauthorized use of a vehicle. Ms. Shipley's here for Mr. Smith. And is there an announcement?
Judge, yes, Your Honor. Mr. Smith had to be in another court, and so Mr. Lewing and Mr. Smith have been working on some things, and they were able to provide Ms. Malfino with some additional information. And we're asking for a little bit of time for Mr. Smith and Ms. Malfino to consult on those matters.
And Judge, I have spoken with Ms. Shipley this morning. That is correct. Mr. Smith sent me an email from the defendant yesterday, and since he's here, if I may, I would just like the defendant to know I have taken it into consideration. I have rewatched the video, although there is a portion of his email that I agree with respect to the ski mask. I just want him to know where I'm coming from.
Sure.
His stack of felonies that is this high doesn't lead me to take everything he says in that email that is self-serving to heart, but I will, based on that, be willing to discuss with Mr. Smith reconsideration of the offer if the court would allow us that time. But I just wanted Mr. Lewing to know I did look at that and what my position is.
Okay, so we'll just do a normal reset. That'll give your attorney and time to visit with Ms. Malfino, and when we come back, we'll get an announcement at that next court date.
Thank you, Judge. And then
Right.
Mr. Smith will be out to see you as soon as he meets with Ms. Malfino. Thank you.
Michael Martin, also Ms. Shipley.
Yes. This is a request for a
Michael Moore
evaluation.
Has something been filed?
No,
Okay,
but that's where he's going.
so this is, we don't need Mr. Martin. I'm gonna reset it. If you'll get Mr. Smith, if he needs, so because he's hired, if you'll make sure if he needs, is requesting a court-appointed evaluation for competency, make sure he also attaches the affidavit of indigency. That gets missed sometimes, and because you're hired, I have to have an affidavit of indigency and to make that determination before someone's appointed. Otherwise, you guys would have to get that taken care of with his.
Absolutely.
Okay, makes sense?
Yes.
All right. And so he's reset Michael Martin.
Yes, ma'am.
Mr. Vasquez? Lost him again. Let's see, Mr. Lewis, Ms. Holmes, you've got Brianne Williams, sentencing.
Brianne Williams.
Good morning. Good morning. You're Brianne Williams?
Yes, ma'am.
And this is cause numbers 26 DCCR, excuse me, 0531. Ms. Williams entered a plea of guilty in that case to a new offense of possession of a controlled substance, a third-degree felony. And then we've got cause number 1830512. Ms. Williams is on probation for injury to a child, and that's a third-degree felony offense. Entered pleas of true. Let's see, I see where. While I look at that, but there was an agreement, it appears, for a 3-year deferred probation, $500 fine, and ISF substance abuse track on the new case with continuing probation and ordering substance abuse, ISF substance abuse on that one. I've received the pre-sentence report and gone over it. Have y'all both had an opportunity to review that report?
Yes, Your Honor. Yes, Judge.
Let me go back and look at something. All right, so it was a 10-year deferred probation from May 20th, 2019 for that injury to a child or elderly, excuse me, individual. And it looks like she pled true to counts 1 through 5, which include that new offense of failure to identify, a new offense of public intoxication, being an out past curfew, and court assessed fees. So I guess what I have a question mark here and an issue and a question. which is why is it just 3 years on a third degree felony possession? When we've already got a 10-year deferred on the other one? I just don't know that that makes sense to me for it to be that low of a number of years for a new offense while you're on a felony offense. I'm not opposed to the ISF and do it and going forward with probation, but I just don't think it makes sense to do a.
It could have been the length of time.
That she had already been.
Right, because the new case, the new offense was from 2024, did not get indicted until this year. So I think that played a part.
Okay.
In it.
But it was, okay, but it still was after she was on probation.
Yes,
But it
it is.
didn't get indicted for
And
a
I
long time.
believe when it originally occurred, that was addressed at a previous MTRP hearing. But it did not get indicted till 2 years later.
Okay, all right. Anything else then?
No, Your Honor.
No.
All right, Ms. Williams, with that explanation, I'm going to follow the agreements that you made with the district attorney's office. And clause number 26 DCCR 0531 find sufficient evidence to find you guilty. However, I'm going to follow that agreement and in that case, defer all proceedings and place you on probation for 3 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation, which includes entering and successfully completing the substance abuse track of the of ISF. And then in clause number 18-30512, I'm going to find that you enter those pleas of true to counts 1 through 5 freely and voluntarily, find those counts true, find sufficient evidence to find you guilty and revoke your probation in that case. But I'm not going to do that. I'm going to follow the agreement, continue you on probation, order as a condition of that probation that you enter and successfully complete the ISF substance abuse track as well. You're being given now all the opportunities that you're probably going to be given. So you're going to go to ISF, you'll get the tools you need in order to remain sober. When you get out, you'll have aftercare. You still have no felony convictions. You still got some great opportunities here to kind of get your life back on track, get off drugs and just live a normal life. If you don't do that and you don't take advantage of this and you continue to test positive and do the things that you did on this one, you're going to end up back in here and you could go to prison in each of these cases for up to 10 years. Do you understand? All right, I'm handing you the trial court certifications in each of those cases that shows that these were agreements that I followed, and so you waived your right to appeal. Good luck to you, ma'am.
Thank you, Judge.
That's the jury, Johnson.
Carl Farrow. Okay.
Good.
Good morning. Are you Carl Farrow? This is 26 DCCR 0100. Mr. Farrow is charged with the state jail felony offense of unlawful possession of certain copper or brass material from October 30th of 2025. And what is the announcement?
Your Honor, if we can get a little bit more time. I've met with Mr. Farrow. This case involves whether he had authorization to possess these copper materials. And he's relayed to me that he does have documentation that had given him the authorization. And so if we could have some time so that he could get that to me.
Okay.
Yes.
All right. So I'm going to do a normal reset, Mr. Farrow. Make sure whatever information you have, you get that, or your family or someone gets that to Ms. Holmes as quickly as possible so that she can then visit with Mr. Smith about it. And then I'll be back out to visit with you before that court date.
Thank you.
All right. You can go back with the bailiff. Donnie Smith.
Donnie Smith.
What?
We have bond reduction.
This isn't how we communicate. It's for me because it's a bond forfeit. I now have to say out loud, and make certain findings if they've had previous bond forfeitures, if they end up paying in sentencing. So I have to have them now look up that. on everybody. Mm-mm. If they're really not really like leading up to the docket, then yes, you have to go back and tell you about that. Good morning. Are you Donnie Glenn Smith?
Yes, ma'am.
And this is cause number 26 DCCR 0072. Mr. Smith is charged with assault on a peace officer. And what is the announcement?
Well, Your Honor, he had previously pled, but he didn't appear for his sentencing.
Oh,
And so,
Okay.
yes, ma'am. So we had done all that, but he didn't appear.
He pled, Judge, that there was no agreement as to the type of probation.
Do you
Or
have
The
a-
type and.
the time.
Is there a PSI? It shows a status hearing, but I should have, it was set for sentencing and he didn't show up. And so there was a bond forfeiture. So I should have a PSI on Donnie Smith. I don't, it's not in the case.
I've got two
No,
copies.
because I'll have notes and,
Okay.
all right, just, y'all can hold him for a few minutes. Let me, figure out where that is.
Yeah.
Mr. Lewis, you've got, Wacy Bork. There's no,
No, Judge, he informed me this morning that he's been able to try to retain somebody else, his own attorney.
oh, thank you. Good morning. Are you Wacy Bork?
Yeah.
And this is 25 DCCR 1213. Mr. Bork is charged with the state felony offense, excuse me, of theft of property. That indictment alleges 3 prior state jail felonies from different dates, which means for punishment purposes, this could be considered a 3rd-degree felony with a punishment range of between 2 years and up to 10 years. And Mr. Lewis, what is the announcement?
Judge, initially came in planning to place this on the trial docket, but after speaking with Mr. Bullock this morning, I guess after his conversation with his family, they'll be able to retain his own attorney.
Okay.
So I asked that he at least have that opportunity, at least one setting before the case is placed on the trial.
So, Mr. Bork, I'll reset your case to normal reset, which is about 30 days. Mr. Lewis is going to remain as your attorney, unless you get someone else hired. If you do, they'll file the appropriate paperwork to substitute in for him. If for some reason that doesn't happen before the next court date, then we'll need to go forward with you visiting with Mr. Lewis and see where we get on your case, okay?
Yes, ma'am. Can I ask a question?
What's that?
My time wouldn't go up. I mean, I should be able to get a lawyer, but my time wouldn't go up like I'm playing with you or nothing like that.
No, there's been no reduction.
The offer is what the offer is. It's probably,
Okay.
it's not going up or down at this point for any reason. If he wants to get his own attorney, he has that right. I'm not
Okay.
holding that against him.
Sure. So that'll remain on the table. That's between y'all at this point. Once there's a rejection later in front of me, then things kind of change as far as accepting plea agreements later. But it sounds like Mr. Nichols is going to leave that on the table for you. Okay? All right, you can go back with the bailiff. Thank you, Mr. Nichols.
And Judge,
Yes.
while we have Mr. Nichols up here, we had the Antonio Riggs on the docket.
Uh-huh.
And before he's brought up, I wanted to speak with you about him. We definitely have a competency issue with him.
Just to fill you in, he was found competent back like in February.
Mm-hmm.
Mr. Lewis has informed me as he seems to have deteriorated some. I checked his jail screen. He has a history of seizures and things like that also affect him. So I think he probably.
We need a new evaluation.
Yeah, and his family is here. They've come into speaking with me or their interactions with him over this time.
Okay.
He's definitely deteriorated, got scattered.
Okay. I'll reset the case. If you'll make a notation for us to do the order for an evaluation on Mr. Riggs, please. And,
Yes, no.
and just make a notation. We could even do,
Sorry.
whichever one we didn't use. Leave that other. Okay. Thanks. You can, we're going to reset Mr. Riggs. And then you've got Christopher Fair.
Yes.
Good morning. Are you Christopher Fair?
Yes, ma'am.
And this is 18-30684. Mr. Fair is on probation for indecency with a child by sexual contact. There's a motion to revoke that's been filed. And what is the announcement?
Judge, at this time, we're prepared to plead the truth for several violations.
Okay, just go through and set up a
Right.
hearing. Give me just a second. And will he waive the formal reading of that motion?
He does.
Mr. Fair, best you can, please raise your right hand. Do you swear or affirm the testimony you give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yeah.
So, Mr. Fair, I have before me a first amended motion to revoke your unadjudicated probation. Shows that you were placed on probation December 2nd of 2019 for the second-degree felony offense of indecency with a child, and that was a 10-year deferred probation. Is that correct?
Yes.
It alleges that you violated your probation. Count 1 alleges that you failed to work faithfully at suitable employment and provide verification of that to probation. And is that true or not true?
True.
Count 2 alleges that you failed to provide verification of performing the community service hours required. Is that true or not true?
True.
Count 3 alleges that you failed to successfully complete an approved sex offender treatment program by a licensed sex offender treatment provider. Is that true or not true?
True.
Count 4 alleges that you are behind in your court assessed fees as of December 9th, 2025 in the amount of $3,290. And is that true or not true?
True.
Count 5 alleges that you failed to immediately report to the probation officer your phone number, employment, and that you now have an email. And is that true or not true?
True.
Count 6 alleges that you failed to report by mail or online to the Jefferson County Probation Department for the months of February, March, May, June, July, August, September, October, November, and December of 2024. And then January, February, April, May, June, July, August, September, October, and November of 2025. Is that true or not true?
True.
Count 7 alleges that you committed the new offense of possession of marijuana January 21st of 2026 in Walker County, Texas. Is that true or not true?
Not true.
Count 8 alleges that you committed the offense of unlawful possession of a firearm by felon January 21st of 2026 in Walker County, Texas. Is that true or not true?
Not true.
Count 9 alleges that you committed the offense of possession of drug paraphernalia January 21st of 2026 in Walker County, Texas. Is that true or not true?
True.
Count 10 alleges that you committed the offense of failure to drive in a single marked lane January 21st of 2026. Is that true or not true?
True.
Count 11 alleges that you committed the offense of having no valid driver's license January 21st of 2026. And is that true or not true?
True.
And count 12 alleges that you failed to immediately report to your probation officer that new arrest. Is that true or not true?
True.
Did you enter your pleas of true? See, the easier way to do this. Did you enter your pleas of true to all of the counts except 7 and 8 freely and voluntarily?
Yeah.
And did you plead true to those counts because they're actually true?
Yes.
All right, then I'm going to find that you entered your pleas of true to all of the counts except 7 and 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation. But I'm going to reset your case for a hearing. Ms. French, do you anticipate that you would try to get anyone from the county to prove those allegations of 7 and 8, or just go forward on what he's pled on?
I think we can go forward on the 10 and split on.
Okay. So then we'll get an updated pre-sentence report done. Anything that you think is important for me to know, make sure you get that information to Mr. Lewis. He'll present it to me on your behalf when we come back. All right, and go back with the bailiff.
Alrighty, friends, that is going to do it for today. I hope you all enjoyed. Well, I say for today, that's a lie. It's a horrible lie on my part. We'll be back tonight, sidebar, 8 p.m. Eastern, 5 p.m. Pacific, right here on this channel, an hour before our friend Lone Wolf's show. So there's no excuse. Come here for sidebar, and then you can go check out his show afterwards. And then you'll have your evening of entertainment fully planned. The wisdom I leave you with today comes from Les Brown. Accept responsibility for your life. Know that it is you who will get you where you want to go, no one else. Truer words have never been spoken. Again, we'll be back tonight, 8 p.m. Eastern, 5 p.m. Pacific for sidebar, and back tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier for the pre-show if you're a channel member. Go have yourself. Let's try that again. Go have yourselves a great day. If there's ever any question as to whether or not we're real here or AI, I stumble over my words much more than AI does, although I pronounce them correctly. The other day I was listening to something that was talking about living in the Arizona desert, and it was talking about the importance of AIR conditioning. Yes, friends, AIR conditioning. So that's how you know it's AI. Anyways, have a great day. Take care. God bless.